All right, morning, everyone. See us on Teams. I think we're otherwise ready to get started. I know I'm not particularly on camera, but I am not the decision maker today. We have our decision makers on the screen. My name is Robin Pope. I'm going to go ahead and make some introductions and get on the record and explain the procedure for today as well. Sorry, just one moment while I get everything in place. Okay, we're going to go ahead and get started. For everyone joining us remotely on Microsoft Teams, just a quick reminder. So, in introductions for today. Today, for the record, today is Tuesday, December 12th, 2023. This hearing is being conducted both in person and telephonically using Microsoft Teams and is currently being recorded. If you have technical difficulties or for some reason get disconnected and are not able to rejoin the hearing, contact Kawana Barbie and I'll give you her phone number if you want to write it down. We will also try to contact you to make sure for those of here I've already spoken to this morning, we are connected digitally. We'll try to give you a call back as well. Miss Barbie's phone number is 615-747-5386. But otherwise, stay on the line and we'll try to connect you to if for some reason you get disconnected. We are present before the Tennessee Assessment Appeals Commission, who have been appointed by the State Board of Equalization to review initial decisions and orders of administrative judges and other related matters. My name is Robin Pope. I currently serve as the Executive Secretary with the State Board of Equalization, and I am designated to sit with the Assessment Appeals Commission as a hearing officer. As hearing officer, I will do several things, chiefly preside at this hearing, rule on questions of the admissibility of evidence, advise commission members as to the law of the case, and otherwise ensure proceedings are carried out in accordance with law. Essentially, that just means I'm here to help make sure we stay on track and everything works accordingly. Kind of a glorified secretary in this case. Chiefly, I am not decision maker. So I do not make a decision on today's appeals. I do not determine the outcome of any of these decisions. That will be done by our Assessment Appeals Commission, who I will introduce momentarily. My role is primarily procedural. I will now make some introductions before explaining how the rest of today will proceed. During deliberations, the commission, we will have one of our staff attorneys for the State Board of Equalization serve as counsel to the commission. I will introduce them as they get up here. As counsel, they will assist the commission during deliberations and offer guidance regarding the legal sufficiency of their conclusions, or otherwise help guide their decision if they have questions for legal counsel. I will now ask our members of our commission to introduce themselves for the record. And from on your video screen, from left to right, we'll start with Mr. Prophet.
Tim Prophet. Name is Don Osborne.
And I will also say, for those that are joining us online, if you cannot hear them at any point in time, please just let us know. I will do my best to make sure that during deliberations they are fully heard. At this time, I will also ask our commission members to identify a presiding member. The presiding member will oversee during deliberations and will concur in the final written order. I heard a motion and second in favor of Don Osborne serving as our presiding member. All those in favor say aye. All those opposed? There being no nays and 2 ayes, motion carries. Mr. Osborne has been nominated as our presiding member today, and he will concur in the final written order. All of the appeals to be heard today are to be conducted based upon the record available before the administrative law judge during the prior hearing. The Assessment Appeals Commission may affirm the decision of the hearing examiner or remand the case for further proceedings. The commission may reverse the decision if the rights of the petitioner have been prejudiced because the administrative findings, inferences, conclusions, or decision is otherwise in violation of constitutional or statutory provisions. That is, did the judge follow and apply the law correctly? 2, made upon unlawful procedure. Did the judge not follow proper procedure, or is there some abuse of procedure? 3, arbitrary and capricious or characterized by abuse of discretion or clearly unwarranted exercise of discretion. Somewhat more self-explanatory, but essentially, was the decision arbitrary? Or 4, was the decision unsupported by evidence that is both substantial and material in light of the entire record? In determining the substantiality of the evidence, the Assessment Appeals Commission shall take into account whatever in the record fairly detracts from its weight, but the commission shall not substitute their judgment for that of the hearing examiner as to questions of fact. Essentially, this being, was there a basis in the record for the decision of the judge? The commission may not replace your judgment for that of the judge on questions of fact, but you're not required to ignore inconsistencies. So the record may have evidence that supports 2 different conclusions, but if the judge made a decision on a question of fact, you have to go with that judge's determination. You can't replace your judgment for that of the judge. However, you're not required to ignore the fact that perhaps contradicting evidence was presented, but whatever the judge determined as a fact, you have to go with. So it's a question that we often have in these cases before the commission. It would be fair to say if you as a commission determine a factual finding is essential to disposing of the appeal, but the administrative judge or initial decision or order does not address that fact, the proper relief is to remand the order to the judge with instructions on what to do. For example, if you believe it is essential to have an exact square footage to determine a proper valuation for this type of property or whatever the case may be, but the initial decision order does not establish an exact square footage from the judge, then you should remand the case back with instructions for the judge to determine that square footage and preferably why it was essential in valuing that appeal. So essentially, that's the kind of difference here. If you're missing an essential fact, you find that judge failed to determine something that's essential for disposition of the case, the relief would be to remand it back with instructions for what the judge should have done. This would be correct even if there exists 1 or more actual square footage measurements in the record. So if you have multiple things in the record that might show an exact square footage, but the judge did not determine that, you should remand it to the judge with instructions for determining that fact. So essentially, this means no new or additional facts, testimony, documents, or other evidence is presented to the commission today. Unless it is related to an irregularity in procedure not shown in the record, no one has raised that before me for today. What this means for everyone on the call and everyone here as well, we will not be swearing anyone in. There is no testimony given to you by you today before the commission. Today, we are here to hear arguments as to why you believe the administrative judge's decision was correctly or incorrectly determined. A copy of the record has previously been presented to the commission members, along with any written argument submitted by the parties in each case before the commission today. We can have a physical copy as well brought down. I do have a virtual copy I can share on my screen for everyone here today. We will proceed with one case at a time, immediately after the other, taking breaks only as necessary. I've already talked to our members who are present today, and I believe everyone is present for our appeals. With that said, I took a brief poll for how long everyone needs to present for our appeals. I'm going to switch up our order slightly. I believe we'll start with Mr. Luther Alcorn versus the Knox County Assessor's Office. And so, Mr. Alcorn, I know you were on the line. If you could give us an introduction, both so we can make sure we can hear and or see you in the room, and then we'll ask the Assessor's Office to introduce themselves before I explain the next steps in the appeal.
Yes, this is Luther Alcorn. I'm Knoxville, and I'm appealing the assessed value.
All right, I can hear you right and clear. I'm just going to ask the Knox County Assessor's Office to introduce themselves for the record, and so we can make sure their microphone is working as well, and then I'll kind of talk about through the next steps. All right, so for the Assessor's Office, I believe we have Mr. Russell. Is that correct?
Yes, sir. It is. My name is Doug Russell. I'm with the Knox County Property Assessor's Office. I'm a certified residential appraiser, license number 4167, and been doing this approximately 15 years.
So these proceedings are informal and board members are allowed to ask questions at any time. Given this mixed media format, typically I will specifically ask the commission if they have any questions at the end of everyone's argument. I will then, once we've heard all the arguments from the parties, I will briefly describe the charge to the commission before handing it over to our presiding member for deliberations. Once we enter deliberations, there will be no more communications between the parties and the panel. This means that they will deliberate and make a decision today on your appeal. However, you will receive then a final written version of that decision within 90 days of today's hearing. Once we've entered those deliberations, your arguments are concluded, and the commission will then deliberate in person. You are not required to stay thereafter. You are welcome to stay and observe, but you are not permitted to interfere with those deliberations. These appeals are generally informal, and we'll start with the appellant taxpayer and then hear from the appellant, which is typically the taxpayer, and then we will hear from the appellee, that is usually the assessor's office. The taxpayer may respond, will then usually go back to the taxpayer for any response to any arguments from the assessor's office before handing it over to the commission. So appellant, respondent, or appellee, and then back to the appellant for final comments, and then we will conclude and go over to deliberations. Before we enter into arguments, I always make sure we read a copy of the initial decision in order up for review, because that is the document that is being reviewed here by the commission. And so for Mr. Alcorn, just give me a moment while I get over there. All right. I have an initial decision in order that was sent out February 14th, 2023. The top of the case caption, it is APD case number 53.01-224829J, being SBUE number 139646, parcel 077DC016 for tax year 2022, and captioned Luther H. Alcorn III, petitioner versus the Knox County Assessor's Office respondent. Order. Statement of the case. The Knox County Board of Equalization, hereinafter the local board, has valued the subject property for tax purposes as follows: a land value of $22,500, an improvement value of $209,500, a total value of $232,000 for an assessment of $58,000. The taxpayer filed an appeal with the State Board of Equalization on August 1st, 2022. The undersigned administrative judge conducted a telephonic hearing of this matter on January 4th, 2022. The appellant, Luther Alcorn III, represented himself at the hearing, hereinafter the taxpayer. The Knox County Assessor of Property was represented by Staff Appraiser Doug Russell, hereinafter the Assessor's Office. Summary of evidence. The taxpayer testified on his own behalf, and Doug Russell testified on behalf of the Assessor's Office. The following exhibits were introduced. Exhibit 1, the taxpayer's comparative sales and supporting documents. And Exhibit 2, the Assessor's Office's valuation analysis. Findings of fact and conclusions of law. The subject in the appeal consists of a 2.9 acres with a house located at 7325 Lancelot Drive in Knoxville, Tennessee. The taxpayer contended that the subject property should be valued at $168,277. The assessor's office requested that the local board's decision of $232,000 for the subject property be affirmed. The basis set out in Tennessee Code Annotated Section 67-5-601 subsection A is that the value of all property shall be ascertained from the evidence of its sound, intrinsic, and immediate value for purposes of sale between a willing seller and a willing buyer without consideration of speculative values. As the party seeking to change the current assessment of the subject property, the appellant has the burden of proof in this administrative proceeding. And cites the state board rule. At the hearing, the taxpayer Luther Alcorn III testified that his contended value was supported by his comparative sales and that his property had increased by 77% compared to other similar properties. The taxpayer relied on a per square foot valuation in his comparisons with other properties. The assessor's office's witness, Doug Russell, testified that their valuation analysis was based on adjusted comparable sales. Based on a review of the testimony and evidence, the valuation analysis provided by the assessor's office is compelling and appears to be a more accurate reflection of the value of the subject property. The taxpayers testified that with a newly assessed value of his property increased more than the assessment of other nearby properties by 77%. However, the Assessment Appeals Commission has repeatedly rejected arguments based on the amount by which an appraisal has increased as a consequence of a reappraisal. For example, the commission rejected such an argument in E.B. Kissel Jr., Shelby County Tax Years 1991 and 1992, reasoning in pertinent part as follows. The rate of increase in the assessment of the subject property since the last reappraisal, or even the last year, may be alarming, but is not evidence that the value is wrong. It is conceivable that values may change dramatically for some properties, even over so short of time as a year. Final decision order at 2. Further, the taxpayer's use of sale prices of nearby properties is not a reliable indicator of property values, as the values they rely on fail to make adjustments in values when compared to the subject property. Factors such as age, building materials, etc., were not taken into account in the comparable sales listed in their comparable sales. So these comparable sales are not a reliable indicator of what the home values are compared to the subject property. The Assessment Appeals Commission has said that for a comparable sales to be relevant, they must be properly adjusted. In E.B. Kissel Jr., Shelby County Tax Years 1991-1992, the commission said the best evidence of the present value of a residential property is generally sales of properties comparable to the subject, comparable in features relevant to value. Perfect comparability is not required, but relevant differences should be explained and accounted for by reasonable adjustments. If evidence of a sale is presented without the required analysis of comparability, it is difficult or impossible for us to use the sale as an indicator of value. The assessor countered with properly adjusted comparable sales contained in their valuation analysis. These sales established a range in value for the subject property of $211,985 to $239,900, which supports the value placed on the subject property by the local board. Respectfully, the evidence introduced by the taxpayer is inadequate and cannot be relied on in this matter. The local board's valuation is affirmed. It is therefore ordered that the following values be adopted for tax year 2021. He then recites those same values at the top of the order, that being a total value of $232,000, following an assessment of $58,000. This initial order was then entered on February 14th, 2023, by Administrative Judge Jerome Cochran, and then concludes with the final pages being a notice of appeal procedures, including appeal to this body, which is why we are here today, following an appeal filed by Mr. Alcorn. With that said, we will then enter over to Mr. Alcorn for your arguments, Mr. Alcorn. Mr. Alcorn, I sometimes provide a prompt just to say, if to help the commission, if you could identify specifically what relief you are seeking from the commission today, can sometimes help the commission determine and listen to the rest of your appeal on the basis for why you believe that that decision I just read was incorrectly decided. But other than that, the floor is yours to present your arguments to the commission. Thank you.
Okay, what I'm asking is that the assessed value be placed at something more in line with the other houses in this area. And as far as Judge Cochran's decision, Judge Pope, does the panel there have a copy of this table, that I sent, and also a copy of my appeal?
It was included in the record. We'll check with our commission members. Do you have
Yes,
a
the
copy
one
of that
with the-
specific table that
yeah.
was included? I can
That's the
get you a
one-
paper copy. Yes, Mr. Alcorn, I'm going to make sure we get a paper copy printed for today. We just send out the digital copy of the record in advance and have a copy of that initial decision in order. I'm going to have my appeals coordinator, Miss Barbie, print off a copy of that page and bring it down for our commission members.
Okay.
I can pull up on our screen in the meantime.
Okay, it's vital that they be able to see the one that I sent to you about, what, 2 months ago? The one with the little addition at the bottom.
Yes, just give me a small moment and I will pull that up and share it with my screen.
And also it would help if they had a copy of the written argument I made after Judge Cochran's decision. Because that pretty well outlines.
I've pulled up a copy of that page you provided
Okay,
on the
that's
screen.
okay. Okay, yeah, it's okay. My contention is that the valuation of my property was basically arbitrary. And if we could just go down, explain this table. First of all, everything to the left of the yellow comes from county records. And of course,
I was just saying, sorry, Mr. Alcorn, I don't mean to interrupt. I just want to make sure our commission members know if you want to stand up to look at the screen, you're welcome to move about. This is the final page of that administrative record, I do believe.
Yes. Now, I assume the very bottom of it can be seen. It can't be seen on my screen because I got something in the way. But I assume the very, very bottom can be seen.
Yes, I have the last line being per square foot assess of my house, open parentheses, house number 1, close parentheses. Yes.
Okay. As I was saying, everything to the left of the yellow comes from county records. And if you look at the gray, which was the previous assessment, of course, my house is at the very top. It's valued at $66 per square foot. And you've got about five other houses as you go down there also in the 60s.
What part are we in on Anthony Tyler?
I'm sorry, say again?
Miss White? Miss White, you're not on mute. Thank you. Sorry, go ahead, Mr. Alcorn.
Okay. The first, I guess, 6 houses on the top are all in the 60s, of which mine is one, 60 some dollars per square foot. Then you've got one that's in the 70s, one that's in the 80s, 2 that are in the 90s, and of course that outlined or that house number 10, which is $48 a square foot. Now, if you slip over to the left and the sort of brownish color grade, you've got the latest assessment. One thing to notice is that the land values for both dates are exactly from one assessment to the other is exactly the same by house. They're either basically 22 and a half or 25 and a couple other little different from that. But anyway, you look at again the per square foot values, and you've got 140 for me, and all the others are less than that, including the one that was back $48 in the previous assessment. It only went up to 93. Now, if you look at the difference, if you average up the houses 2 through 11, no, there's the other 10. Well, let me backtrack just a minute here. Something I failed to mention. That is, the reason these houses are on here as opposed to some others, I went trying to find houses that are similar to mine. Now, there's the ranch, wood siding, built the same time, and basically the same quality. And of course, some of those are what Judge Cochran said I didn't take into account. The age, I did take that into account. You can look on each of these. They're all ranches. The siding on all of them are above average, except for 2 that are further down below that are just average. They're all built in the 70s except for two. One was built in, was it 2007? One was built in sometime in the 90s. I can't see it here. There's all these dates are listed. There's house number 7 was built in 94, and house number 4 was built in 2007. So those are sort of outliers for ages, but the quality is the same. Everything's the same, except of course the per square footage. And mine comes up with 140 in this latest assessment, and the others are all less than that, including the one that was $48 a square foot in the previous assessment. Now, if you the average of the house of the per square foot average value of the houses 2 through 11, those 10 houses in the previous assessment was $73 a square foot. In the latest assessment, it was $98.50 a square foot. My house was at $66 a square foot in the previous assessment, and it shot all the way up to $140. In other words, the other 10 houses on average increased 35%, but my house increased 112%, 3 times as much. Now, I'm sure the county assessor thinks that, and maybe it's true, it doesn't matter, that the good sales in this area of houses makes houses go up, and the job situation is great. Maybe all that's true, but why is it that it affected only my house? And one other point I'd like to make from what Judge Cochran said, to the very best of my knowledge, I never used the word sales in my presentation to him, but he kept saying in his write-up that I was using sales. I was not using sales. I was using exactly the same thing I just finished using here. The comparative assessment values between the two dates, 2017, 2022, between 10 similar houses and my house. Therefore, what I'm asking is that the assessment value of my house be more in line with all the other houses and not 3 times the other houses. Whatever argument can be made for increasing the value of my house, the assessed value of my house, should also be used for the other houses. In other words, the county was using a different measuring stick with my house as compared to the other houses. 3 times is ridiculous, and if that's not arbitrary, I don't exactly know what is. That's about all I have to say at this point.
All right, usually at this point in time, I will ask our commission members if you have any questions for Mr. Alcorn. I heard a yes. We're just gonna make sure we get you in front of the microphone so we can hear that.
Pinned you on your chart. That's very interesting. It looks like on the number 8 that was on your chart, it shows a 1974 house. Do you have the assessor's property card on that?
I can barely hear you, but you asked if I have the assessor's something card. I don't have it. No, whatever it is. No, I don't have that.
Okay.
I have.
My question was on your house, I think they have an effective age of 1995. And I was just wondering, I was just trying to see how they did their effective ages, but that's probably not got anything to do with this.
No, my house is house number 1. And if you look there, it says 1974.
Yeah, but the effective age is 1995 on the card that I've seen in the file. And so how the assessor determine part of, is a difference. Why your house is different is because there's something that either looks different in the field or, whatever. And I was just trying to see from the information from the previous hearings, what differences those were, from the evidence that's in this file. It looks like on the assessment card, your house has an effective age of 1995, and it was built in 74 or whenever, but the house's number 8 shows 1974, and I was just curious what the effective age on the assessor's card was. I was looking through the file and I don't see it. Of course, my internet's real slow because it's running off my phone. But
No, I don't,
anyway.
yeah, I'd like to make one point here that I failed to make before, and that is, there have been no improvements on this house. To the best of my knowledge, there have been no improvements made on any of the other houses. So, I can assure you, I've not been living out, I was not living out in the field before 1995. This house has been here since 1974, and there have been no improvements on this or any of the other, to the best of my knowledge, any of the other 10 houses. So the only thing that's changed between 2017 and 2022 is the passage of time.
Any other questions from our commission members?
Mr. Alcorn. Over the spreadsheet.
Mr. Pope, will I have a chance to address that page to the commission myself?
Mr. Russell, sure, yes, but it's not your turn yet. We'll switch over to you in a moment. Mr. Osborne, I don't know if they can hear you at all on there. You have to really get comfortable right into the microphone.
Yeah, I can't hear anything.
Can you hear me now?
I can hear
Barely.
you now.
My question is, this information you've got with regard to the size and the land values, is that from the property record cards in the assessor's office?
Mr.
That's
Osborne,
from the,
is that question for Mr. Alcorn or for Mr. Russell?
For Mr. Alcorn.
Okay.
Yeah, I got all this information off the county website. So I'm not sure what you mean by card, whatever they got posted on the website. Everything to the left of the yellow comes from the county, their website.
So when they show the square footage of the house, is it the actual square footage or is it some other areas such as garages and porches that may be included in that?
No, that's
you know?
derived. That's derived from taking the total value, which in my case would be 232,000, subtracting the 22,500 for the land, and then dividing that by the square footage that's given by the county. And that's how I come up with the 140 in the case of the 2022 assessment.
So all of this information is from the county records.
That's correct.
Okay, I have no other questions.
Mr. Bowles, any questions?
I know you're basing.
I don't know if they can hear you at all with that. You really have to
Can
get.
you hear me?
Yeah, yes, sir, I
Yeah.
can.
Okay. Looks like all this is done from assessment records with, I don't know, these from sale 2 through 12, are they in the same market area as your house?
Yes, okay, something else I failed to explain. When I decided which houses to use in comparison, I looked up and down Lancelot Drive, which is where I live. I could only find one house, and that's house number 2. So I then went to the next street up to I wanted to get 10. I wanted to get a good representative number. So I went to the next street up, which is Glastonbury, and I went down house by house by house in the county records to see which one matched my house. And what you see there is what I did. So yeah, they're all within a few tenths of a mile of each other.
Okay. Did you, are any of these houses 2 through 11 or, have any of these houses been sold in the last, 2 or 3 years?
Not that I'm aware of.
Yeah, we're looking at these, at this information without the benefit of any sales data. Maybe that was done, from the other side. I don't know, but, yeah, okay, that's basically all I have at this time.
If they were sold, one would think that the sales would reflect in the assessed value that the county came up with. Maybe not. I don't know.
Yeah, what is sometimes done, at least, is if there was sales, the realtor's comments on that particular sale sometimes has an influence from the buyer's perspective on how much money he's willing to pay for that. And you have to go a little bit deeper than what the assessor's got. And right now, I don't have any of that information.
All right, well, if there are no more questions, we'll hand it over to Mr. Russell for the assessor's office to present your arguments as to same questions apply as I asked Mr. Alcorn. If you could also help identify what you are asking for the commission to do today. And then otherwise, the floor is yours to present your arguments.
Okay, what I'm asking is that the commission reduce.
Oh, sorry, Mr. Alcorn, that was for Mr. Russell. We're handing it over to the
Oh, okay.
assessor's office for their presentation.
Okay, I'm sorry.
Mr. Pope, first I'd like to ask, can I interject some information on Mr. Alcorn's presentation, that page that he was showing the commission?
Are you asking me to highlight that page on the screen again?
Well, what I was wanting to tell the commission is some of the information on here comes from 2 different websites. He took half of the information from our website, which is, he notes on page 137 of his, of all the stuff that was presented to the judge. Now, the other half come from a website that's www.countyoffice.org. And that website has no affiliation with the Knox County office in any way. Because when I got this information originally, I wanted to go through it and see if there's any sales. I try to take the sales from ones that the homeowners will supply if they have any. If not, I get my own. Now, from that, on that first column that's highlighted in a gray, not a gray, but a orangish, the subject, the $140 a square foot, is figured out with land and the improvement. But all the other ones are done with just the improvement, not the land included. So those prices per square foot are incorrect. And then if you go over to the far right where he's highlighted everything in yellow comes from that website, www.countyoffice.org. And none of those numbers line up with anything in the Knox County Property Assessor's office. Because when I was getting those numbers, I was trying to figure out where they were coming from and how he got his numbers. So, that has no, and when you figure it all out, it has no bearing to anything on our side. And also, 7 of those assessments have no basement, and 4 of them have a partial to full basement that are somewhat been renovated or upgraded. But that's all I have to say for what Mr. Alcorn has brought to y'all's attention. What I'd like to say as far as what the judge has ordered, I think he did a good job on far as his write-up. I want to say that on page, let me On page 25 of the administrative record is my sales comparison overview, which what I had done is I took 3 sales that were within 2 miles of the subject that had sold within 12 months of the effective date of January 1st, 2023. And I made proper adjustments that, you know, come to a conclusion. My weighted value was $239,000. But to err on the side of caution, because Mr. Alcorn did not give us the opportunity to do an interior observation of the property. All we could do was an exterior of the property. So therefore, I assumed that the interior was average. I don't say it's poor, don't say it's excellent, but based upon that, that's what I went with to make my adjustments to come up with a value of 239, but I just wanted to affirm what the county board had done at $232,000. And that's all I have. And all the information in the administrative record is for, you know, just reference as far as the market in Knox County. And it's gone gangbusters over the last, you know, 3 to 4 years. And, I have flipped over 70 houses in the last 15 years. I own multiple rental properties, and I see the market every day, especially in my job. So his house would truly go for a lot more than that, but I just wanted to be fair and, say $232,000. That's all I have to say, Mr. Pope.
All right, that's fine. I'll ask if the commission has any questions for Mr. Russell.
Mr. Russell, was your radius a 2-mile radius from the subject?
Yes, sir, it was. The furthest one was like 1.9 miles.
Okay, within that radius, there were only 3 sales similar to the subject?
Oh, no, sir. There was probably a total of 15 or 20 I could have picked from. But, I wanted to pick the ones that were most like his, no basement. All these had crawl spaces just like his did. And they were as close to his is 48 years old. My sales were 39, 42, and 45 years old. So I tried to, as much as I can, equalize everything with this home.
Those ages, they were physical ages?
Yes, sir.
Okay.
Any other?
That's no further question.
Mr. Russell, just to clarify what the question I had earlier, when you look at your sales in his home, I think the assessment card shows that 1975, he says 74, but 1995 effective ages, age for his home. Is your sales kind of in that same ballpark on as far as effective ages?
Yes, sir. One of the first thing I did, because when he brought it to our attention of just the assessments of other houses, I wanted to make sure he was equalized as far as everybody else across the board in his neighborhood and those neighborhoods that are those type of houses in other neighborhoods as far as an effective age. And all of them were 1995 and, or they were newer built homes. So those would be higher.
Okay. I just wanted to make sure that was consistent. So.
Yes, sir.
Mr. Russell, have you made a actual physical inspection of the subject property that's in question with regard to the exterior and how it compares with the other properties within the neighborhood?
Yes. Now, I physically didn't go to this property. I have a team that has gone to hundreds of these for me because of my appeals. I have so many that, I have to get somebody to do them. I wouldn't have enough time to do it. But they come back with pictures. They take pictures of interior and exterior as they go. They talk to the homeowners. They get all the information they have as far as if they've renovated, if they've upgraded, what their deficiencies are in their house, around their house. If there's any external obsolescence, is there a railroad track behind you? Is there a creek running through your yard or something? We try to get all that information taken into account when we do this. Now, when the man who did the observation for me, his name Mark Kidd, when he went, Mr. Alcorn was very nice and very gracious, he said, and said he was just, helping as much as he can, but he wouldn't let him do an interior observation of the property. So that's where I was stating that, we have to stay on some parameters. So I just, narrowed it down to an average condition on the interior.
Okay, very good. I have no other questions.
If there's no more questions from our commission, then I'll hand it over to Mr. Alcorn. Mr. Alcorn, this is your opportunity to make any final comments or responses before we enter into deliberations.
Yes, Mr. Russell was questioning the accuracy of this chart. When I first started out, I said that the county records, or the figures on this chart, the county come from the county records, everything to the left of what is in yellow. Now, he mentioned something about, he seemed to be saying that more than that it did not come from county. Where the only thing that came from that county office website was the yellow part. And I didn't even discuss the yellow part in my discussion. He also questioned the accuracy of my numbers. And I as he was talking, I went down with my calculator and checked. And it's simple enough for anyone to do, just based on this chart. He was saying that I divided the square footage into the total value of the property, land and house. That's not true. It'd be simple enough just to, for example, just take, I don't know, the second one, house number 2 for the 2022 assessment, $250,200. I did not divide that number by 2,720 square feet. I subtracted the 22,500 and then divided. So these, I'll stand by my numbers. My numbers on this chart are correct. And the same thing is true. He again mentions about the great sales in the area and so on and so forth. Why did it affect only my house? Why did it not affect the others? And just looking at the number, to have an assessed value of 3 times the average of the other, that's absurd. That's all I've got.
Any final questions from our commission? Hearing and seeing none, I'll introduce your counsel for this case, Mr. Matthew Childress, sitting across from me. Oh, pardon me, someone. Oh, looks like Mr. Austin got out. Am I in? All right. Yes, we'll enter deliberations, and that will be the time for your discussion. From this point in time, there'll be no more communication between the commission and the parties or anyone else on the call. This will be your deliberations for this case. Mr. Osborne, you're a presiding member. Yeah, typically if you do Robert's rules, you'll have a motion and a second, and then you would deliberate that motion as presented with any comments on there. But I know we can also otherwise just generally discuss the case, however you want to go about doing things.
Any discussion?
Yeah, really. This chart he's got, I'm sure, but it's in his mind okay. But has he not consulted before he got up to this point? Not consulted with licensed certified residential appraiser and an appraisal report that would at least be specific to his house and the market. And then if there is a difference between one licensed appraiser to the assessor, which I understand the other gentleman also has a license, then we can look at those reports and see a lot more than we're seeing now. Correct.
Yes, I agree. I'm sorry.
Just a reminder to try to really speak into that microphone. If you need to take it off too and hold it, you're welcome to do that.
I totally agree. It would have been much easier for the administrative judge as well as us if there had been a market appraisal, you know, and so I just really feel on the evidence. I looked over the file over the last few days and looked at this, and there's question some of these other websites versus the county's actual website. Sometimes there's confusion in that. Of course, that wouldn't have been enough really because a lot of these don't appear to be sales. So I really would like to entertain a motion through a discussion to uphold the administrative judge's decision.
Okay. We have a motion to affirm the administrative law judge decision. Do we have a second?
Second.
All those in favor of the motion or any amendments or conditional comments on the motion as presented? All those in favor? Oh, sorry. The ayes carry. Any nays? No nays. Unanimous ayes. With that, the motion carries. So the next steps for Mr. Alcorn and Mr. Russell, we will send a final written copy of the decision from today within 90 days of today's hearing. That decision will then address any appeal remedies that you may have, including possible appeal to Chancery Court if you should wish to pursue that. With that, that concludes your business today for, I believe, Knox County. If you have no other appeals, as well as Mr. Alcorn, you're otherwise free to disconnect. Thank you for joining. At this time, I usually ask if anyone needs a break or anything like that. We want to continue. I'll look to our commission members to see. I'm fine to continue. I usually just offer, make sure we check in.
Thank
to
you,
continue,
Mr.
then
Pope.
we'll continue. Thank you.
And thank you, Commission, for your time.
All right, I'm going over my notes here again. We've got three left, three other appeals. I have Mr. Felix Gooden and versus Shelby, who both identified they needed about 30 minutes each. We then had Huriski, who I believe the taxpayer identified about 10 to 15, and Mr. The counsel for Bledsoe, I think about maybe 30 minutes. And the National Health, I think I had you both at 15 minutes. I'll enter in order. We usually go from our shortest appeals to our longest. So in terms, by my notes, it would be National Health would be our next appeal. All right, as our parties get up here, moving over to National Health, I will just note preliminarily that this administrative record was rather large. So if you do want to reference anything, I'm happy to bring it up on the screen or anything like that. But that page numbering is going to be pretty important for this case. Let me pull up that. All right, I'm going to go ahead and read the initial decision in order to get underway, and then we'll have our parties introduce themselves and then proceed into arguments. So I have the initial decision in order of this appeal as being entered on November 16th, 2022. and captioned in regard to National Health Investors Property ID 059F, Group C, Parcel 12 for tax years 2020, 2021, and 2022 for Warren County, appeal number 130069. Make sure that the initial decision order statement of the case. The Warren County Board of Equalization, hereinafter the local board, has valued the subject property for 2020 tax purposes as follows: a land value of $217,900, an improvement value of $6,286,200 for a total value of $6,504,100 for an assessment of $2,601,640. The taxpayer filed an appeal with the State Board of Equalization, hereinafter the State Board, for tax year 2020 on June 19th, 2020. The taxpayer requested without objection that this appeal be amended to include tax years 2021 and 2022. The undersigned administrative judge conducted a hearing of this matter on September 14th, 2022. The appellant, NHC Healthcare, hereinafter the taxpayer, was represented by its attorney, Frederick Hitchcock, at the hearing. The Warren County Assessor of Property, the assessor's office, was represented by its attorney, Robert Lee. Summary of evidence. The evidence considered in preparation of this order includes the testimony of the parties and the exhibits as listed below. Testifying on behalf of the assessor's office were George Hoke from the Division of Property Assessment, and on behalf of the taxpayer was the taxpayer's representative, Charles Dugan. Exhibit 1, the taxpayer's valuation analysis. Exhibit 2, the assessor's office's valuation analysis. Exhibit 3, then he notes at footnote 1, late filed, corrected, page 240 to Exhibit 2. Exhibit 4, the taxpayer's rebuttal exhibit, and Exhibit 5, late filed, the Tennessee Skilled Nursing Homes document. In his footnote 1, he notes the assessor's office has later determined that the page was not incorrect and no late filed exhibit was needed to correct the error. Findings of fact and conclusions of law. The subject property in this appeal consists of a 79-room nursing home facility located on 3.2 acres at 928 Old Smithville Road in McMinnville, Tennessee. The nursing home was built in 1970 with an addition built on in 1989. The taxpayer contended that the subject property should be valued at $1,229,987 for tax years 2020, 2021, and 2022 based on their submitted valuation analysis. The assessor's office contend that the value placed on the subject property by the local board of equalization of $6,504,100 should be affirmed. In support of this position, the assessor's office introduced a valuation analysis prepared by the DPA that indicated a value of $6,991,500 for tax years 2020, a valuation of $7,097,800 for tax year 2021, and a valuation of $6,336,600 for tax year 2022. The basis of valuation set out in Tennessee Code Annotated Section 67-5-601 subsection A is that the value of all property shall be ascertained from the evidence of its sound, intrinsic, and immediate value for purposes of sale between a willing seller and a willing buyer without consideration of speculative values. As the party seeking to change the current assessment of the subject property, the appellant has the burden of proof in this administrative proceeding. At the hearing, the taxpayer's representative, Charles Dugan, testified that the subject property consisted of a 79-room 79-room skilled care facility that is licensed for 115 beds. He further testified the rooms have no kitchens and the rooms have a shared shower facility. According to Mr. Dugan, the main funding for the nursing home is through Medicare reimbursements. Mr. Dugan testified that the taxpayer's valuation relied on the income approach. Its income approach utilized a capitalization rate based on the CBRE Class C rates. The taxpayer's reconciled income approach relied on a 2-year pre-COVID average to determine the tax valuation of the subject property and did not include temporary COVID relief funds. Under cross-examination, Mr. Dugan testified that 75% of income for skilled nursing homes is attributed to services such as nursing services, food, etc. For this reason, the taxpayer's net operating income was reduced by 75%, with the remaining 25% of the income being attributed to rent. Mr. George Hoke from the Division of Property Assessments testified on his valuation analysis on behalf of the Assessor's Office. Mr. Hoke testified that his valuation in support of the Assessor's Office's valuation was supported by his cost approach analysis. Mr. Hoke valuation analysis stated that the cost approach was the best approach to value the subject property due to the fact that the income nor sales approaches factors in the value of the certificate of need. Mr. Hoke testified in his valuation analysis that he reluctantly and with objections, end quote, submitted an income approach. His submitted income approach includes a 20% intangible personal property reduction to take into account personal property and in the certificate of need that is not related to the 75% factor for services deduction that the taxpayer included in its analysis. The Assessor's Office's income approach included no 75% service deduction, included the COVID relief funds, and an overall capitalization rate of 14.327% due to its belief that the property is a Class B property under the CRBE classifications. Under cross-examination, Mr. Hoke testified that the COVID relief funds received by the taxpayer in 2020 and 2021 were included in his analysis. With respect to the taxpayer's 75% service deduction, Mr. Hoke testified that his analysis only included actual expenses, and he believed that the taxpayer was double dipping expenses by deducting actual expenses and taking the 75% service deduction also. With respect to the proper valuation method to use, based on a prior decision by the Assessment Appeals Commission and this administrative law judge, footnote 2, it's NHC Healthcare, Washington County, appeal number 127814 and 131234 as the prior decision of the underlying judge. The income approach is the preferred method over the Assessor's Office's cost approach. He then cites in regard to National Health Corp Limited Partnership Assessment Appeals Commission DeKalb County tax year 2016. The AAC upheld that the taxpayer's income approach analysis was to be accepted in determining the valuation of the subject property, in that case, a nursing home. The Assessor's Office's witness, Mr. Hoke, testified that due to this being a special use facility with a certificate of need, that the aforementioned case is not applicable. I disagree and believe that the Assessment Appeals Commission decision in that case is still controlling. The Assessment Appeals Commission did create a special use caveat or exception in their decision, and the Assessment Appeals Commission has not since then issued any decision that I am aware of that changes their accepted approach in the valuation of nursing homes. I would note that in a prior case involving a nursing home, footnote 3, he cites NHC Healthcare Anderson County for a different appeal number. I allowed the parties to introduce a cost approach analysis due to an agreement between the parties that this was the preferred method of each and that they had reached similar valuations with respect to the value of the property at issue, along with the value of the land. In this case, no such agreement is presented, and I believe the Assessment Appeals Commission prior decision would be controlling regarding the proper valuation approach. In the National Health Corp Limited Partnership case, the Assessment Appeals Commission adopted a method to determine valuation of the subject property, a nursing home, of dividing the net operating income by the loaded capitalization rate and then deducting the land and personal property values. Both parties have submitted an income approach analysis. The main difference with each approach is the taxpayer's use of the 75% service deduction of COVID funds, and differing capitalization rates based on building classification under CRBE. With respect to the taxpayer's 75% service deduction, I find that this deduction is excessive and agree with Mr. Hoke that it constitutes double dipping of expense deductions. Further, I cannot see any past case law that recognizes this practice as an acceptable method of calculating value under the income approach. The taxpayer's arguments were not persuasive in justifying such a massive reduction after deducting expenses already. I further find that the taxpayer's deduction of COVID funds were inappropriate for tax years 2020 and 2021. Like the previous deduction, I cannot find any authority that supports this deduction under an income approach. While I certainly recognize that these were funds granted under extraordinary circumstances, they nevertheless were income to the taxpayer and should be treated as such. These funds cannot simply be ignored, and perhaps they could be included under a smaller service deduction, but there is no need to speculate since it has been determined that the taxpayer service deduction was excessive. Based on the taxpayer's excessive service deduction and inappropriate deduction of COVID funds, I find that its submitted income and net valuation analysis is unreliable and cannot be trusted in determining the tax valuation of the subject property. Therefore, having failed to carry its burden of proof in this matter, the valuation as determined by the local board is affirmed. Order. It is therefore ordered that the following values be adopted for tax years 2020, 2021, and 2022. That is the same values, I believe, as before. A land value of $217,900, a improvement value of $6,286,200, a total value of $6,504,100 for an assessment of $2,601,640. He then concludes with applicable remedies, including appeal to this body, which is why we are here today. With that said, I just want to make sure I get the most update information on this case. Our case caption. Oops, wrong one. All right. I do have that this appeal now includes tax year 2023. So the value decision will carry forward and also apply for tax year 2023. That was filed with the commission before today. Let me see. I think everything else is still the same. That is the order up for review. Once again, for our commission members, you may affirm the decision of the hearing examiner, that decision I just read, or remand the case for further proceedings. You can also reverse if you find that the rights of the petitioner were, if the decision was in violation of constitutional statutory provisions, if the judge did not follow the law correctly, was made under unlawful procedure, was otherwise arbitrary or capricious, unsupported by evidence in light of the entire record. And remember, if you find the judge was a fact was essential to the disposition of the case, and the administrative judge failed to determine said fact, the proper relief would be to remand it back to an administrative judge with instructions for what facts to determine and why that would be imperative in evaluation of this property. With that said, we'll otherwise hand it over to our appellant, which I believe in this case is, help me out here, the appellant is Mr. Dugan. Okay. And so we will have Mr. Dugan, you present first, and then over to Mr. Lee, and then we will come back to you for final comments. Don't let me forget to, and I'll test it as well, make sure you do talk to the microphone, because that's how we'll record you here for today as well. I remember if I forgot anything else. I don't think I did. With that said, Mr. Dugan, introduce yourself, and then I'll have Mr. Lee introduce himself, and then just make sure I can hear you both on our microphones are working, and then we'll get started. Oh, keep talking. Let me see. Yeah, I'm not hearing you. Maybe I'm glad we tested that. Let me make sure it's on.
Hello. Okay, thank you, Mr. Pope. My name is Charlie Dugan. I am a registered agent with the state of Tennessee. And I represent National Healthcare Corp and have for 25, 30 years. This appeal has to do with a nursing home, as Mr. Pope described, that's located in McMinnville, Tennessee, 51 years old. And it contains many of the same facts and questions that were involved in the appeal that we had a year ago before this body, where Chairman Russ was in attendance. Has to do with the income approach, which the State Assessment Appeals Commission and State Board of Equalization have repeatedly deemed to be the appropriate method of valuation. But in this particular appeal, for the first time, Judge Cochran deemed our removal of food, nursing service, and other income from the income, he deemed it to be, quote unquote, excessive. although that was exactly the same method we used in the Johnson City case and what we've used in other cases that have been affirmed by the AAC and various ALJs. To include service and food income in the valuation of real estate, in this case, a nursing home, means that rent would be $10,000 a month for essentially a dorm room that's 12 by 25 feet, many of which have no showers. They go down the hall and share a shower, sparse bathroom. $10,000 a month rent for that accommodation is clearly ridiculous. So CBRE and the National Investment Center for Seniors Housing prescribe a 75% allocation from total revenue for food, nursing services, transportation, cosmetology, et cetera. The remaining 25% would be for the rent. And that evidence is in our package here. It's in the record. It's on page 176 of the AAC official record, the CBRE and the National Investment Center data showing the 75% allocation for services. And then it's in our testimony, page 45, as well as our income approach tables on page 44. Our problem again is that the ALJ stating in this case, in a bit of a reversal from previous cases, that it seemed excessive is directly contradicted by the data presented by the taxpayer in the hearing and the testimony that we provided. The second issue here has to do with the ALJ's inclusion of COVID funding that was temporary. No prudent investor would assume that that income would be recurring in future years. So they would not base their purchase decision for this property through a stabilized fee simple analysis using these temporary funds. So the ALJ included $1,625,000 for 2022 and $1,686,000 for 2021 as ordinary income, which is simply wrong. And I'll leave it at that.
Any questions for Mr. Dugan?
Mr. Dugan, this is a complicated case, but do you have a P&L on this property?
Yes, sir. It's all in the hearing record. 3 years of P&Ls. And they're summarized on the second page of our evidence, which is page 44 on the hearing record.
In your P&L was the COVID money counted?
It was included in the income, yes, sir.
In turn, you have said is not typical of this type facility.
It's not typical for any income producing commercial property. The COVID funding was it was a 2-year event and not going to recur, and prudent investor is not going to base a purchase decision based on income that's not going to happen again in the future, hopefully.
Typically, these facilities have a high expense ratio. Do you know about what yours is running?
Yes, sir. They typically run about 90%. If you're above 90%, you're probably not making money. This facility has over 60% Medicaid census, which is the lowest form of income that a nursing home can derive. Doesn't mean that that NHC takes any different care of those folks than the folks who pay private and almost double the daily rate. But the fact is, when your facility is older, when you have shared showers, when you don't have amenities, 51 years old is past the Marshall and Swift useful life recommendation for these facilities. So this one is well maintained, it's clean, but you can't cure the issues that drive a 60+% Medicaid census. Folks are not gravitating to nursing homes the way they did 10, 20 years ago in the first place, but especially when they get to be this age. Home health care is becoming far more prevalent.
And expensive.
Very expensive, but the government is reimbursing home health care higher than they ever have in the past, which helps.
Fairly complex case. Without a lot more information, I don't have any other questions.
Well, from our end, it seems that the issues are fairly clear about whether or not food income, service, nursing income should be included as rent or not. The ALJ said yes, in contrast to his previous decisions, and I don't know how that could be looked upon as rent in any way, shape, or form.
Was there any kind of stipulations made with the COVID funds as to what they could be used for, to your knowledge?
To my knowledge, there is not. I don't know, to be quite honest with you, whether there were any strings attached to it or not. I know in my business, we received COVID funding for payroll protection and so forth, but in this particular case, nursing homes received quite a bit of COVID funding there in the short term because it was very difficult to get folks to come to work. And they had to pay a lot more wages to get the nurses and the attendants to come, frankly, in very close contact with older folks. And there was an awful lot of risk involved. And the COVID money helped to mitigate that. And I don't know whether there were specific instructions as to how it had to be spent or not.
Okay. Was your normal annual income stream affected during this time?
I don't know if you have access to the evidence here, but on page 44 of the record, you can see that total revenue, the income statements are summarized here on this page. I used a 2-year pre-COVID analysis to eliminate the question of whether COVID was good or bad for the business. And you can see here that the 2-year average pre-COVID gross income was $11,682,000. In year 2020 and year 2021, that number was $12,560,000.
I pulled up that page you're citing for the administrative record on the screen. If our commission members would like to walk over and see it, feel free. This is again page, that red number, page 44 from the admin record.
And then all of the detailed income and expense statements are in the hearing record as well. This is just a summary.
And this is a 51-year-old facility.
Yes, sir.
Sure, you've been through the property many times. What functional obsolescence would you think may exist? You mentioned the showers not being available, have to go to some common area for shower. What other situations, in your opinion, that?
There are no kitchens in the rooms whatsoever. There's no sink except in the bathroom. Bathroom has, if you could envision a 1965 dorm room at UT where I went to school, for instance, there's just not much there. And this $6.5 million value that was sustained by the ALJ represents almost $100,000 a unit for these rooms, which just doesn't make sense. Showers that are shared and are at the end of the hall, different wings. Nursing homes are typically built with wings so the nursing stations can see all the doors. Putting your parents in a nursing home where they have to go down the hall to take a shower with other folks is not in vogue, to say the least. So that would be the number one. The sparse bathroom, no kitchen facility in the rooms. Those are other functional obsolescence points. You have clouded glass. Again, NHC does a wonderful job of taking care of senior citizens in this state. They're one of the best taxpayers. They're one of the best employers. But there's only so much you can do with a rectangular red brick building that's built many, many years ago, as the photographs in the package that we provided, and it's in the record, will demonstrate. To McMinnville, Tennessee, to sell this building for $6.5 million, just the real estate, just doesn't meet the litmus test.
The building was originally constructed in 1970, right? 71, thereabout?
Thereabouts.
Okay. Was there a major addition added to it after that time?
There was an addition. I would not call it a major addition. I don't have an addition listed in our report here, but I work on 120 of these for NHC, and I can't tell you positively whether there was any addition to this one or not.
Okay. That's all the questions I've got. Private?
I just wanted to clarify. So the showers, they have to go to a shower room.
Correct.
And is a lot of your newer facilities, or the newer facilities with NHC, do they have kitchenettes in the rooms?
Depending on what the service is, what the utility of the facility is. Nursing homes typically aren't going to have full kitchens. They're going to have a sink and a counter, but they're not going to have an oven or a range or that sort of thing.
That's what I was wondering. I did that. So you're basically just saying a sink that the nurses use in the room, and as well as the patient. And okay, I understand that.
Mr. Bowles, I'll just any other questions? Oh, looks like he's got one.
What's your occupancy rate?
So I didn't hear you on the, I just want to repeat your question. You said, what's the occupancy rate, Mr. Dugan? Was just because the microphone didn't pick you up.
I'm looking here to see. We've got that information in our package. I'm looking to see if it's in the summary. I'd have to go through the document and identify the occupancy.
Okay, I may have another question then. That's an important factor, but is your revenue stream, private revenue stream, lower than, equal to, or greater than a nursing home that's more adapted with proper facilities?
Lower than.
Any
You know, these income properties, you're operating, you say, on a 90% expense ratio. I don't know of an income property that can make any kind of return on 10%.
Nursing homes are break-even enterprises at this age, for typically, many times they stay open because if you're not losing money, you have a certificate of need that can be used when and if circumstances, economics change. That CON, although there are very, very few of them requested or administered in the last 10 years in the state of Tennessee. It's one reason why you keep the doors open, is to keep the CON.
Yes, this certificate of needs are issued by the state, and that's based on a lot of factors in that area. Let me think a minute. That's all for now.
Questions?
No.
We have no other questions.
Okay, yeah. At this time, I'll hand over Mr. Lee to introduce yourself. Make sure that microphone's working.
Yes. Can you excuse me, can you hear me? Is it working?
It's working.
Thank you, Commissioner members. My name is Robert Lee. I'm the attorney on behalf of Warren County here today. We are seeking that the administrative judge's order be upheld. The burden of proof is on the taxpayer at the administrative judge. The judge clearly found that the taxpayer failed to carry that burden of proof. While the taxpayer's agent would say that he included food in the income, that's inaccurate. What he decided was the 75% deduction in the taxpayer's analysis was excessive. The adjustments made by the taxpayer's registered agent was excessive, and therefore could not be concluded to be relied upon. One of the indications was the taxpayer, there was no evidence as to that from anybody from the company. There was no evidence presented to support that deduction. There was no documentation or oral testimony from a party for that. The only testimony was from a registered agent that is on a contingency fee basis. So therefore, he has a direct interest in this valuation. So the judge found that the 75% was excessive. The judge also found that the COVID funds should have been included, should have been considered in the valuation in the income approach. The taxpayer did not include those. If you look at the page 44 that Mr. Dugan has relied upon, the income is going up on this property. The best I recall, the occupancy was in the 90s, so it's very well occupied. There is a CON. That is what is valuable on these properties. And that is why the commission in the past, a long time ago, relied upon the cost approach. There was a decision in DeKalb County that they used the income approach. The state, the Warren County assessor still feels like the cost approach is the best indication of value to get away from the intangibles. But both approaches were submitted to the administrative judge on behalf of Warren County, the cost approach and the income approach. The income approach and the cost approach supported supported the increase in the valuation of this property of $6.5 million. You have to realize that the taxpayer is responsible for carrying the burden of proof. The judge found that the taxpayer's income valuation analysis was unreliable and cannot be trusted due to the fact that there was inadequate evidence presented. It was just surveys or information taken as 75%. Nothing was supported. When you look at the actual income and expense statements for this property is a subpart of National Health Corporation, NHC. This is National Health Investors. It is a subpart. It is a leased property. It is not, it's run by NHC. It's owned by NHI, and so it's leased. There's also fees going back to NHC that looks to be excessive. That's in the evidence. That's in the documentation. So there's a lot of expenses going off of this property on that to get to the 90-something% expenses. So this is a productive property. As Mr. Dugan said, it is a well-managed property. It has been updated. There was an addition to it. It's not a pure 1970-something property. The property record cards will indicate what changes have been made. There was an addition in the 80s, I believe, and that's reflected on the property record card that's in the record. So the administrative judge found that without any documentation, evidence, or supporting testimony, this 75% deduction was just taken. And then there was additional expenses taken. So the judge found that he found like this was double dipping of expenses. Going to the COVID funds, he found that he was not persuasive in justifying such a massive deduction on the expenses. And as to the COVID funds, the administrative judge found no, it was inappropriate to deduct the COVID funds. COVID funds were short term. We understand that. There was a stopgap. Hopefully we will never see them again. But they were there to sort of prop up these properties that needed it. And that's what the COVID funds were. You look at the record on page 44, the income and expense, those COVID funds are under the line of the gross of the total revenues. So those funds were $1.5 million in 2020 and $1.6 million in 2021. That is below the line for the total revenues, which was a deduction to come out with the total revenues excluding COVID funds. The burden of proof here today is on the taxpayer to show that the decision is a violation of a constitutional or statutory provision. It is not. It is made upon an unlawful procedure. It is not. The decision was not made upon an unlawful procedure. Number 3, that the decision was arbitrary and capricious, characterized by abuse of discretion or clearly unwarranted exercise of discretion. The judge weighed the evidence. That's what the judge did. Found no evidence to support the 75% deduction and then expense deductions. Number 4, it is unsupported by the evidence and is both substantial and material in light of the entire record. Again, the judge found there was insufficient evidence to uphold the taxpayer's position. The body shall not substitute its judgment for that of the hearing officer and the weight of the evidence. Those are the criteria established by the statute 67-5-1506. We contend that the judge weighed the evidence. Based on the evidence, he found the taxpayer did not carry the burden of proof. And there was no sufficient testimony or evidence presented to support the conclusions of the evaluations. While he did not point out, the testimony also supports that the valuation was conducted by a person that had a financial interest in the determination of the property, in that there is a contingency fee arrangement. So we ask that the administrative judge's decision be upheld and the appeal be dismissed.
Any questions from our commission members of Mr. Lee?
Mr. Lee, in your comments, I heard the word lease. Is that an effective agreement between the NHC and the operator?
We have asked for a copy of the lease on several occasions, Mr. Bowles. We have been unable to provide that. It's not been provided to us. It is a lease. If you look at NHC's 10K reports with the SEC, it recognizes that there's a master lease for several properties and that there's payments based on a rent at some stage plus a percentage of the gross income. We have been unable to obtain evidence as to support that lease or what that lease is evolving.
Any other questions?
Unfortunate.
Very unfortunate, Mr. Pope.
I'm just a little bit unclear about the double dipping. Could you expound on what the judge is referring to here as a 75% deduction, part COVID?
Yes, Mr. Prophet. The judge, what the taxpayer's agent did was take a 75% deduction off the top and say that that was for food and other services, doctors or whatever. And then they used the remaining 25% to take the deductions for maintenance, insurance, and other deductions. So it looked like to the judge that that was a double dipping, taking 75% off the top and then also applying other deductions to come out with the NOI.
Thank you.
Mr. Lee,
Mr. Osborne,
looking at the
Mr.
information, it appears that your opinion of value is derived from the cost approach. Is that correct?
I believe Mr. Hoke's analysis had three approaches. He did do the income that's cost. I don't think he used the sales. He did on the land, but not on the building itself. But he did do a cost approach and an income approach, and I think all three supported. I mean, both of those approaches supported a value higher than what the assessment value, appraisal value for property tax purposes was.
Right. Going back to looking over the cost approach, it appears that the land value has been assigned at $640,000, $200,000 an acre. That was on the grid summary. That's Warren County Nursing Home land sales.
Yes.
There was 5 sales used to arrive at price per acre of $200,000 an acre, or $640,000 for the subject site. And here's that the current value that's assigned to the land is only $217,900. Is that correct?
I'm trying to find.
do you have a little red page number on there? We could. Okay. Okay, yeah, I'll just pull it up. 03. Oh, got it.
Yes, Mr. Osmond, the Warren County Nursing Home land sales grid is on 0307. Yes, sir.
And the estimated value is 200,000 per acre for a total of 640,000.
Correct.
Is that correct? And that was the land value assigned in the cost approach that was used.
That is correct.
One more question you may or may not be able to answer. Was there any consideration given for any functional obsolescence in the cost approach? I see that the effective age has been assigned for 30 years, which is much less than the actual age. Could be because the property is well maintained and there's been some renovations and things of this nature. But do you have any idea as to any consideration for functional obsolescence that was used?
I do not recall, Mr. Osmond. There was discussions about that in the record, but again, the burden of proof was on the taxpayer. So Mr. Hoke had done a cost approach, which has found his conclusion.
0366 is the summary sheet
The summary sheets.
of the cost approach. On one of the sections, it was, and I'm assuming that was the original section has the effective age of 30 years, and then the other section that was built later at a later time has an effective age of 21 years. So I was just trying to see if there was any consideration given for any functional obsolescence that may exist.
The best of my recollection, there was discussion, and Marshall evaluation includes a element of functional in it, but I don't think there was any additional functional obsolescence given.
Very good. So with regard to the land, it's should be considered at 640, or was that just in the calculation of the cost approach?
That was in the cost approach. You have to value the land separately.
Right.
And so that's what that market analysis was done
Okay.
for those sales. And an indication of value was $600 or something thousand dollars, $200,000 an acre.
But the current value that's being valued for the land is 217,900. Is that correct?
I need to look at the property record card if I could find that, Mr. Osborne.
Do we need to take a break? Here,
Property record cards are found
here,
beginning
Mr. Lee, we're
42.
242. I'll pull up that page and we'll take a quick, just 10-minute break, come back at 11. For those online, I'm gonna leave the call up, as well as we'll keep the recording going just in case. So just be mindful of that. I don't want to dislodge it and potentially lose anything. But we'll take a quick break and we'll come back right at 11. But yeah, we're back on the record. Mr. Lee, I forget where we left off, I think, with that question.
Property record card.
I could, Mr. Pope, on page 0243 of the record, that is the current property record card for tax year 2020, which would be the same property record card for 2021 and 2022. The land value was $217,900 at $68,100 per acre. There are 3.2 acres. Mr. Hoke's analysis can be found at page 0307, based on sales in the area, 5 sales, indicating by market analysis of a $200,000 per acre, for a value of $640,000. Does that answer your question, Mr. Osborne?
Yes, it does. It does.
As for your question about, if you also look at the property record card, it notes that the building has undergone a renovation and addition in 1990.
Okay. Yeah, I thought I saw that somewhere in the record. I have no other questions.
It also shows that there's a kitchen addition in 92 or something there. 26 by 42. Okay, no questions.
With that, we'll hand it back to Mr. Dugan for any final responses or arguments on this appeal.
Okay, thank you. Once again, the AAC and multiple ALJs have ruled the income approach to be the proper method of valuation for these senior housing properties. That it is on the record in the remand and adoption of the taxpayers analysis in the Johnson City case a year ago for this body. The identification of 75% of income attributable to nursing services, food, transportation, et cetera, is not my opinion. It's in the record. It's in the evidence that was provided and was derived through CBRE and the National Investment Center for Seniors Housing. Both sources are used by the DPA and various assessors. So these are sources that are widely known and accepted. They are exactly the same sources and same data that was used in the previous AAC affirmed case in Johnson City. Regarding the lease, NHI and NHC are related companies. They were in the same building, same offices, same officers, and they were required to split by the SEC 30 years ago. When that happened, they created a master lease for all the properties that they had jointly owned, and there is no rent paid. There is no arm's length lease. There is a finance charge that you'll see below the line on each of these annual statements that is an amount that NHC pays on behalf of NHI. So there is no lease to examine for a market value. The CON, as Mr. Lee properly said, the CON, the certificate of need, is the most valuable component of this property. It is not taxable as real estate. The fact that the ALJ ruled in previous cases, including the Johnson City case, using the allocation and the data that the taxpayer provided, that was exactly the same 75% allocation as was used in this one, but in this case deemed that to be, quote unquote, seems excessive, is arbitrary and capricious. The decision that was made here, the IDO, should be remanded for examination and with instruction to review the income and proper allocation of income to rent, or should be reversed to be in accordance with previous AAC rulings.
Any questions from our commission? All right, hearing and seeing none, we'll otherwise enter deliberations. Just a reminder for our commission too, if you do have any questions, you have to exit deliberations and reopen the record. But other than that, we'll enter. So at this point, there's no more communication from our parties and our commission members. Your counsel for this case will be Emily Bennett. She is back to your left. Other than that, our presiding member is Mr. Osborne, so take it away.
Discussion.
With any detail.
Oh, I apologize. I just really do have to. We just have to get you on the recording, so you have to talk in the microphone. I just can't hear.
Do you have anything on the cost approach with any detail? That's number.
We're looking at the administrative record 0366. Yes. Okay. Thank you.
Well, it's been a while since I've cost approach. Do you have any concerns with the 75%? His question he brought up.
I'm sorry, Mr. Prophet.
How that was included
gonna-
in the he referred to how the DPA and others used in the cost approach. And he's saying that the judge unfairly looked at that. Yeah, to me, it looks
Mr. Osborne, sorry, y'all, you have
like double dipping, but
like a podcast.
I'm sorry. Yeah, we're close to the mic. To me, it does look like double dipping, but do you have any concerns with that?
Well, there's no question about it. Nursing homes have always, to me, the nursing homes have always been a complex property today.
Mhm.
Because you have the intangibles with regard to any method you choose,
Mhm.
especially with income approach, got to deal with the CON that is generating a lot of that income.
Mhm.
Typical, here again, it's been a long time since I've looked at any published information, but
Mhm.
75% has been a typical percent of
Mhm.
gross revenue that's applied back to expenses of running and operating
Okay.
that type of facility. That goes back to the income
Yeah,
value.
yeah. That was the only question I had.
I'd just like to say, I think both parties have done an excellent job in trying to explain their positions and arrive at a reasonable value for the property. Here again, it sort of weighted down with some variable unknowns that has always posed a problem in the evaluation and with regard to the COVID money that was issued to the property. Some people think you should use it. Some people think it was just a crutch for the business to keep operating. Here again, I think both parties have done an excellent job in providing the information. Any questions?
I don't have any questions.
Do I have a motion?
I see where the COVID money, kind of put a bump in the road, but I think the county handled that well in their approach, and I think that's probably, to me, what caused some of these problems. But I have a motion to uphold the administrative judge's decision.
I second, I guess.
Has been made to affirm the administrative law judge's decision, and I confer, so take a vote.
All those in favor of the motion to affirm the administrative law judge's decision?
Aye.
Aye.
All those opposed? There being no nays, the ayes are unanimous. The motion carries. That concludes this case for today. We'll send that final written order within the next 90 days. Well, we only have 2 cases left. Going back to my notes again, I know we might have had some estimations, but we've got Mr. Felix Gooden down for 30 minutes in the assessor's office for additional 30 minutes, but I've got Mr. Huriski Incorporated versus Bledsoe for 10 to 15, and I believe Mr. Sharp said about 30 minutes. So with that, I think Huriski is the shorter. So we'll move over.
Mr. Pope,
Yes.
when I gave the estimate of 30 minutes, I was actually thinking about the entire time. Just wanted to clarify that.
Okay. Well, if there's no issue, we'll move over. We'll do Mr. Gooden. Mr. Sharp, he says that's fine. Mr. Austin, I assume that's okay with you as well. Mr. Gooden, are you still on the line?
Secretary Pope.
Oh, yes.
I am scheduled to be in another hearing, and I've got a little bit of travel time. I'm a little
Okay.
concerned. I'm a little concerned about my availability. So I've done a poor job of scheduling my day, I guess. But
Well, I think we lost Mr. Gooden, so you're in the room. So happy to sorry not to flip flop at everyone back and forth, but
okay,
Mr. Austin, if it's okay, we'll go ahead with you then.
Thank you, Secretary Pope, and thank you, Commission. I'll try to stick to my time estimate as best as I can.
All right, just a moment we get over here. Mr. Sharp is in the room. He's moving into position. We've got Mr. Childress as counsel for the commission. We've got our board members. You'd be surprised at how fast I can read. All right, here we go. We've got the administrative record previously sent to the parties or signed by me on November 29th, 2023 with a certified technical record. That certified technical record has the order on page 17, which would be approximately page 18 in red. Wait, that's order of continuance. All right, here we go. The order. In the matter of Who Risky Incorporated, petitioner versus Bledsoe County Assessors of Property responded. This is APD case number 53.02-22470720J, SBUE number 139238, parcel 6439. This is for tax year 2022. The order, written by Jerome Cochran and issued on March 30th, 2023, begins with order. This matter was heard via telephonic hearing before the undersigned administrative law judge on February 13th, 2023. The taxpayer Who Risky Incorporated was represented by its attorney, Thomas Austin. The Bledsoe County Assessor of Property was represented by its attorney, John Sharp, the Assistant General Counsel of the Tennessee Comptroller's Office. The Assessor's Office's motion to dismiss asks that this matter be dismissed pursuant to Tennessee Rules of Civil Procedure 12.02 subsection 1 on the grounds that the State Board of Equalization lacks jurisdiction in this matter. Specifically, the Assessor's Office has alleged that the State Board lacks jurisdiction due to the fact that delinquent taxes are owed and have accrued on the subject property for tax years 2021 and 2022, and the taxpayer has failed to pay the undisputed tax related to the property's appealed assessment for tax year 2021 and 2022. The taxpayer's response to the Assessor's motion to dismiss, the taxpayer stated that the taxes that are owed are not delinquent for tax year 2022, and the taxes for 2021 are currently in litigation. Tennessee Code Annotated Section 67-5-1512, subsection B, provides that, quote, on motion of the city or county to whom the tax is owed, the State Board of Equalization will dismiss the appeal of any taxpayer who fails to pay delinquent taxes that have accrued on property that is subject to an appeal, or who fails to pay at least the undisputed tax related to a properly appealed assessment. Emphasis added. The State Board of Equalization has routinely dismissed appeals pursuant to this section on the motion of the assessor. See Marquette Bright, Lincoln County Tax Years 2014, final decision order May 2nd, 2016. Tennessee Covered Bridges. He cites 3 other cases. I will just skip that and you can for now. Additionally, in Leaf Hotel Pigeon Forge, Sevier County Tax Year 2013, final decision order November 7th, 2014, the Assessment Appeals Commission upheld the dismissal of an appeal, even though the taxpayer had paid the delinquent taxes before the hearing before the commission. Based on the testimony and evidence presented, the taxpayer has delinquent taxes for tax year 2021 and has failed to pay their undisputed tax for tax year 2022. While the taxpayer has provided arguments as to why taxes for tax year 2021 and 2022 have not been paid. Unfortunately, Tennessee Code Annotated Section 67-5-1512, subsection B, provides no exceptions to the requirement to pay all delinquent taxes and any undisputed taxes prior to the hearing. While there are certainly no intent by the taxpayer to not pay the property taxes for tax years 2021 and 2022, and they are intended to pay them after their hearing before the State Board of Equalization and the Chancery Court, regrettably, based on Tennessee Code Annotated Section 67-5-1512, subsection B, I have no alternative but to dismiss the taxpayer's appeal. The statute and decisions of the State Board of Equalization are clear, and the appeals must be dismissed due to delinquent taxes having accrued on the subject property, and that the tax year has failed to pay the undisputed portion of the undisputed tax related to the property, which are the subject of this appeal. It is so ordered, then concludes on the third page. March 30th, 2023, issued by Jerome Cochran, and then concludes with available appeal rights, including appeal to this body, which is why we are here today. That is the initial decision and order by the administrative law judge. That is what we are here to review. With that said, I believe the appellant in this case is Huriski, represented by Mr. Austin. So Mr. Austin, I will have you go first, and then have a followed by questions, and then I'll have Mr. Sharp go, and then you'll have a final opportunity for any response. All right, Mr. Austin, give us a shout, make sure we can still hear you, and feel free to proceed at your ready.
Thank you, Secretary Pope, and good morning, Commission. I appreciate you allowing me to appear before you this morning. I've had my camera working earlier today, but for some reason it's not working right now. That's probably a benefit to all of you who don't have to see me. So anyway, so the first thing I want to say is that at the time of the hearing, the undisputed portions of the undisputed back taxes were paid. So that's incorrect. The order is incorrect. And we'll get into that in just a second. But on behalf of Huriski, we're appealing the decision for the administrative board. And what we're seeking today is that the case be remanded back down to the administrative judge for a hearing on the tax assessment. And the judge erred by applying the incorrect legal standard and not following the procedures, and that the facts are unsupported by the evidence. So the law in this case, and it's in his order, I don't really know how this, well, I have an idea how this got messed up, but the law in this case requires that prior to the hearing, that all back taxes in dispute are paid. And all undisputed taxes were paid prior to the hearing, which was heard on February 13th, 2023. The order that Secretary Pope just read mentioned that the hearing was done on February 13th of 2023, and Huriski paid all of its undisputed back taxes for tax years 2021 and 2022 on January 30th of 2023. That's going to be an administrative record, and I think we use the red numbers. Is that right, Secretary Pope?
Yes, I'm happy to pull up a page for the administrative record. Just let me know what page it is.
Yeah, sure. 028, and that's going to be all the way through 0031. Those are going to be the 4 tax receipts, which are the city and county taxes for the undisputed back tax portions.
I'm sorry, I'm sorry, one more time. What was that red number?
0028.
Oh, okay. I was so close.
There you go.
All right. And again, for our commission members, if you want to walk around the room and look at our screens, feel free.
So those are going to be, there's going to be two receipts for the county and 2 receipts for the city. So those, yeah. Now, Mr. Sharp's position, and he's done a good job. I've got to give him credit of making these issues murky. His position is that, well, this hearing was initially set on December 28th of 2022, and Huriski had not had its back taxes paid before December 28th of 2022. However, prior to that hearing, Huriski was granted a continuance, and that continuance was unopposed by Bledsoe County. And that order is in, I think it's going to be on page 16, Mr. Pope.
The order of continuance issued.
And it says appeal by taxpayer was set to be heard before the administrative law judge Jerome Cochran on December 28, 2022. And then this is important language. Prior to the start of the hearing, the taxpayer requested a continuance to file a response to assessor motion for dismissal. And then it says the assessor's office has no objection to the continuance request by the taxpayer. So there's 2 important things there. One, that prior to the start of the hearing, so that means the hearing did not happen. And then there was no objection to the continuance requested by the assessor. The assessor formally filed its motion on January 6th. We filed a response, and then we had a hearing on February the 13th. And the taxes were paid on January 30th. So more than 2 weeks before the hearing, the taxes were paid. There's no dispute that these taxes are grossly inflated. The page 32, if you'll go to page 32, Secretary Pope, please. It shows that the state's assessment is $3.54 million, and the tax amount, which is the CBOE value, which we appealed, was $6 million, $6,149,000. So it's, even if you took the state's assessment, it's grossly overvalued. Wariski's value was $900,000. This is a very large industrial building that has been dilapidated, and there's a long history of my client's predecessor in title, who's now in federal prison because of the fraud that they did when they owned this property. So there's a long backstory to this. But the facts are this: that before the hearing on February 13th, all of the undisputed back taxes were paid. And the law that Mr. Pope or Mr. Sharp cites in his brief, the NRA Pigeon Forge, and the other cases, they all say that they have to be paid. They have to be paid prior to the hearing. Well, the hearing was not until February 13th, and Pigeon Forge, the hearing was done on April 7th of one year, and then the taxpayer paid it the day after, and then they paid it a few more days after. Well, obviously that's not before the hearing. I think the state's objection should have been to the continuance, but they did not, as the record reflects, did not object to the continuance. Therefore, the hearing was done on February 13th. The undisputed back taxes portion were paid. And so there was an error in the factual basis, and the incorrect legal standard was applied, and the administrative law judge did not follow the correct procedure. So we're asking that it be remanded back down and have a hearing on the tax assessment.
Any questions
That's
from our
all.
commission members?
I just want to make sure I'm perfectly clear. The original hearing was set for January 6th. Is that correct?
No, it was, the original hearing date was set for December 28th of 2022.
December 8th. Okay.
28th.
28th of 2022. You had a continuance that put the hearing off to February 13th.
Yes, sir.
Okay. I just wanted to make sure I had my timeline straight. Okay.
Yes, sir. And the back tax portion was paid on January the 30th. The undisputed back
Yes.
tax portion. Okay.
Yes. For 2021 and 2022.
Yes, sir. And I will say, though, I don't think it's really important. The 2022 taxes were not delinquent until February 28th of 2022. So they never were delinquent, but they were paid on January 30th before the hearing anyway.
Thank you.
I have no questions.
I have no questions.
If you change your mind, we're still going. With that, I'll hand it over to Mr. Sharp. And then Mr. Austin, it'll come back to you before we have the final word.
Thank you.
The little green light on there, so we can.
Good morning. Good morning, members of the Assessment Appeals Commission. My name is John Sharp. I'm an Assistant General Counsel for the Comptroller of the Treasury. Today, I'm here representing the Bledsoe County Assessor's Office. Mr. Zach Ohlendorf is the Bledsoe County Assessor, and he is online, I believe, with us. Is that correct, Secretary Pope? Is he online? Is he?
Yes, it does appear that he is in the online gallery.
Okay. And I am representing his office here today. What we're here for today is we're here to ask you to affirm the administrative judge's ruling. The administrative judge got this decision correct, and we would ask that you uphold that decision. The facts of the case are very straightforward. And those facts are that the undisputed portion was not paid prior to the hearing of this matter. This matter was set for December 28th of 2022. I recall that date very well. I was scheduled for leave that day, but this hearing, Judge Cochran said that he could set this hearing, and I canceled my leave and attended this hearing. There was a motion filed to dismiss the appeal for failure to pay the taxes, the property taxes that accrued. On page 18018, Secretary Pope.
Yeah, sorry, just give me 1 second. You said 18?
Yes, sir. It was an online hearing, and the parties came online much like we are here today. While Judge Cochran was doing the preliminaries, I presented the motion to him to dismiss the appeal for the unpaid portion of the property taxes. Judge Cochran asked the appellant what their position was on this, and they asserted that they were blindsided by this. They had no knowledge of this, and asked for a continuance. The Bledsoe County Assessor agreed, and I agreed to that continuance. The hearing, and he allowed enough time for them to present a motion, a response to that. That response to that is found on 014. In that response, they acknowledge on the third paragraph, Roriski shall also pay the undisputed portion of the 2021 back tax amount, which shall be from July 12, 2021 through December 31st, 2021 at the appraised value of $900,000. They acknowledge that they have not paid the property taxes that are the subject of this appeal. They acknowledge that there. That is a fact that they had not on December 28th, 2023, when this appeal was called and set to be heard and the parties were there, they had not paid those property taxes. That's an undisputed fact. Judge Cochran issued an order of continuance, and he says, the taxpayer has requested a continuance in order to file a response to the assessor's motion for dismissal. And as he says, we had no objection to that. That's on 018. On page 021, this is the administrative judge's order. In the second paragraph from the top, Based on the testimony and evidence presented, the taxpayer has delinquent taxes for tax year 2021 and has failed to pay their undisputed taxes for tax year 2022. While the taxpayer has provided arguments as to why the taxes for tax year 21 and 22 have not been paid, unfortunately, Tennessee Code annotated 67.5.1512B provides no exceptions to the requirements to pay all delinquent taxes and any undisputed taxes prior to the hearing. The administrative judge correctly dismissed the taxpayer's appeal for their failure to pay these property taxes. Subsequently, the administrative judge received a request from the taxpayer for reconsideration. They made these arguments to the administrative judge and asked him to reconsider his initial decision. That is found on page 024. Wariski filed a petition for reconsideration to the administrative judge and put forth the fact that they had paid these property taxes now after the hearing. They provided the receipts of where they had paid those. On PDF 72, the administrative judge issued an order denying the petition for reconsideration of the initial order. And the judge says in the fourth paragraph, unfortunately, the taxpayer's arguments are the same arguments that were made at the hearing and are not supported by any new evidence and provide no basis for reconsideration of the initial order. Accordingly, the taxpayer's petition is respectfully denied. The administrative judge considered these facts and denied their decision. The basis that the administrative judge cited is found on page 169 of the administrative record. And that is a similar appeal heard before another administrative judge. The name of that is Timothy Hill Children's Ranch. And that's found at page 169. On page 171, if you would go, the analysis and conclusions of law. The undersigned administrative judge is not without sympathy for Timothy Hill Children's Ranch apparent misunderstanding regarding the requirement to pay the taxes, or at least the undisputed portion thereof, on the property during the pendency of the appeal. It is clear both from the testimony of TCHR's representatives, the post-hearing filing, and the immediate action of TCHR in paying those delinquent tax bills after the hearing that TCHR was both willing and able to pay the property taxes. It appears that TCHR's intent was to delay paying the property taxes only until the tax liability or the exemption therefrom could be established at hearing. There is, however, not a reasonable cause exception to TCA 67-1512B5 or any other process by which the administrative judge can credit TCHR's intent rather than its actions. Based on the foregoing, the assessor's motion to dismiss is granted and TCHR's appeal is dismissed. It's the same fact scenario that we've got here. Another decision that the administrative judge Judge Cochran based this current decision on is found at 174 in the record. And that's LEIF Hotel, Leaf Hotel, Pigeon Forge. And it's a final decision in order of the Assessment Appeals Commission. And it states, this is an appeal by the taxpayer from the initial decision and order of the administrative judge who dismissed the taxpayer's appeal due to the accrual of delinquent taxes. The appeal was heard in Knoxville on September 9, 2014, before commission members. And at the bottom of that decision, findings of fact and conclusion of law, the taxpayer acknowledged that he failed to timely pay portions of the 2012 and 2013 taxes due to an oversight on his part. However, he had paid all taxes due on April 28, 2014. The Assessment Appeals Commission cites back to 67-5-15-12 and cites it and says, provides on motion of the city or county to whom the taxes is owed, the State Board of Equalization will dismiss the appeal of any taxpayer who fails to pay delinquent taxes that have accrued on property that is a subject of the appeal. The appellant bears the burden of complying with the statute, and while the commission is not unsympathetic to the taxpayer situation, the construction of the statute and its requirements are not mere technicalities. The usage of the word will mandates the dismissal of an appeal in which the taxpayer fails to pay the delinquent taxes that have accrued on the property that is the subject of an appeal. Accordingly, we must affirm the administrative judge's order. It's the same set of facts we're dealing with here. And we would ask you to uphold the administrative judge's decision. I'm glad to answer any questions that you have.
Any questions from our commission at this time with Mr. Sharp?
No questions, just want to clarify. Both sides showed up December 28, 2022 and started the process. And that's when there was actual court date or an actual date with the administrative judge. And both parties were present, whether it's video or otherwise.
Yes, Commission Member Profit. All parties showed up. On that December the 28th, Mr. Austin was on the call, I was on the call, and the administrative judge was on the call as well on that December the 28th day, 2023. And that's the day that I made that motion to dismiss the appeal.
I just wanted that to be perfectly clear. So
That's correct.
no more questions from me.
No. No question.
All right, I'll hand it back over to Mr. Austin for reply and any final arguments before we go into deliberation.
Thank you, Secretary Pope. So I think, and there's really no dispute about these facts, and there's really no dispute about the law. The law seems clear that you have to have the hearing, you have to pay the back taxes prior to the hearing. The only thing in dispute is when was the hearing? And the court speaks through its orders and its records. And if you look through the order and the records, it is crystal clear that this hearing took place on February the 13th of 2023. If you look at page number 18. Secretary
Let me get there. Sorry. Yep, I'm moving. Page 13?
18.
All right, 18.
Yes. on the order of continuance, you know, the second sentence, prior to the start of the hearing, which means there was no hearing on December 28th, 2022. So there was no hearing on December 28th, 2022. And then if you go down to page 20, the order clearly states this matter was heard via telephonic hearing before the undersigned administrative law judge on February 13th, 2023. There was no reference in the order to the December 28th date. And the taxes were paid before the hearing. In order for the commission to rule against Wariski, they're going to have to make the finding that the hearing was conducted on December 28th, 2023. And the order would be directly in conflict with that. The order says that the continuance was granted prior to the hearing, and this case is set for February 13th. And then the February 13th order, or I'm sorry, the subsequent order says that the hearing was held on February 13th. Before February 13th, Wariski has paid its back taxes. And all of the taxes in dispute were paid on February 13th. So thank you.
Any questions of either Mr. Sharp or Mr. Austin before we move into deliberations?
I have one question for Mr. Sharp. Mr. Sharp, on December 28th, is it in the record here that we can see that your motion to dismiss, is that in the record here that we have today?
Yes, I can pull it up. Wait, is it? Let me see here. So I'm just going to start at the top. All right, we have our notice of administrative record, and then we have the certified court record. We've got the notice of appearance. Sorry, we only have the only thing in the administrative record I have is Wariski's response and opposition.
If I could say something, can I say something on this?
Was it a verbal motion? Is that?
Yes, it was a verbal motion, and then he filed a written motion on January, or he sent a written motion on January the 6th that never made it into the record.
Okay, to be clear for everyone too, I will say I don't have a copy or a notice that anything was missing from the record. We sent out this finalized copy of the administrative record on November 29th, and the certified technical record that was sent by APD was sent back in May 19th, 2023. I do not have that as part of the administrative record. If you're raising that as a regular procedure or anything like that, or if we need a supplement, you need to do it immediately, right now before the end of the hearing. Otherwise, it will not be considered as part of the administrative record. It's not before the commission today.
The appellant said that it was on January 6th. Is that correct?
Said what was, excuse me?
The motion to dismiss.
Yes, the written motion to dismiss was submitted to me on January 6th.
Okay, so it was submitted to you and we don't have it in our file. Okay.
Any other questions from our commission members? I'm just scanning through our administrative record.
Mr. Sharp appears to have a copy of that there.
At page 147, there was at page 147, there is a notice of a hearing, but it's dated for December the 12th. My recollection is that there was a conflict with one of the parties, I believe the administrative judge, and I could, once again, that's not before you. There was a conflict and asked for that December the 28th date. And as I said, I recall that because I was scheduled for leave and I made the accommodation to come to work.
Z-
So
0147 is talking about today's
Yeah,
date,
sorry.
2023.
that's incorrect. But
I'm
the
sorry?
notice-
So just to go through our administrative record, just for clarity too, I'm just gonna kind of recite. We sent out a copy of the administrative record on November 29th, 2023. The first thing in that is a certified technical record that was sent out by APD. Their timeline has the following. November 3rd, 2022, there was a due process hearing request. That's typically the notice of hearing for the administrative judge. That notice of hearing on its face says December 28th, 2022. The next thing they have in the administrative record is the notice of docket letter. It's a standard thing that APD sends out confirming receipt of that case. They then have the notice of appearance filed by Mr. Sharp. The next thing in the administrative record is Heurisky Incorporated response in opposition to Bledsoe County Assessor property motion to dismiss. We then have the order of continuance issued January 23rd, 2023.
Excuse me. The order to dismiss, or the request to dismiss was when?
I do not have that in the record. I'm just reading from the record. Yeah, no, you're right. Nor was it supplemented prior to today. And then we have that final order from Jerome Cochran issued March 30th, 2023.
Secretary Pope, to answer Commission Member Profit's question to me, you're correct that on 003, that is the notice of hearing that was sent forward for 12/28/22.
Any other questions from our commission members at this time?
Would it be out of order for us to get guidance from commission's attorney?
You could, so that would be Mr. Childress. He's sitting across from me. He's tax counsel with the State Board of Equalization and is here to serve as your counsel. Well, Mr. Osborne, I can't pick you up on the, could you,
Yeah.
sorry, you just,
And what would be your legal guidance in trying to maneuver the dates around to where it's either dismissed because of unpaid taxes or the taxes were paid prior to the hearing? That's the question I have to you.
Sure, yeah. Unfortunately, neither the state board rules nor the statute 67-5-15-12 specify in terms of the question for this appeal. That's really the question that's been argued as to when that date is, when that undisputed date has to be. Now, granting with the original hearing scheduled on December 28th, it is certainly within the administrative judge's discretion, but it is a little unusual for them to grant a continuance. Now, again, this is an unusual situation. I haven't seen one exactly like this, so I will respectfully refrain from advising you as to what you should do. I think it's really just a judgment call in terms of the totality of the documents before you, and then also the arguments that have been presented. That's not really an answer to your question, but there's not anything that's on point that says A is right versus B is right.
yeah, the administrative, will comment, the administrative judge cited the statute. If you'd like to see the statute, I'd get you a printed copy. That was my.
Yeah, and I've looked at the statute and even the state board rules. It doesn't say anything more than what's previously been cited in some of the motions, which have been referenced. They're both in the record, and then what was referenced today during the arguments.
Okay, thank you.
Mm-hmm.
Any motions from members?
We're in session
Oh, we're not, well, yeah, we're still asking questions. You ready to enter deliberations? Sorry, you ready to enter deliberations? Okay, then, yep, go ahead, yep.
When, in my view, of course, I've had a experience in court. When an attorney, brings something out like this in the original date of December 28, 2022, even though it's not written, both parties knew that this was an issue, a major issue. Then, of course, everyone agrees, both sides agrees that on January 6th, everyone's definitely aware of this, still prior to the time that the taxes were paid in January 30, 2023. So no matter how I look at it, they didn't comply with not only the law, but when you look at the previous rulings from other judges that's been held up, like the administrative judge brought out a couple other cases. I really don't see, even though I have compassion and understanding for not knowing about something from the appellant, as the other cases that were ruled against, many times people get in court and don't understand or know all the ins and outs of the law, but that's still no real excuse. It's we uphold the law. So it's my opinion that we should uphold the administrative judge's ruling, but I'm open to anyone else's opinions on discussion. That's just the way I see it.
Yeah, that's a good way to look at it. One way to look at it for sure. It's really a unfortunate situation as to what was said and what was understood. The only thing I've heard is that certain events took place at a certain date, whether they were understood or not. And I believe that's what the administrative judge is trying to allude to. That's all I got.
I would like to add too, in the other cases, as well as this case, the appellant did have the funds, as the Children's Ranch and the other cases that was brought up in the administrative judge's decision as examples of how this has been used in the past. They did have the funds to pay the taxes, on an undisputed amount. And of course, there was only 1 year, it looks like, that was delinquent or out, but they went ahead and paid 2022 as well. So that's all I have.
I'm struggling with the situation, to be perfectly honest with you. Looking at the statute, it clearly states that it provides no exceptions to the requirement of any delinquent taxes, although taxes were paid prior to the hearing. So I'm open for a motion from the members as to the course of action you would like to take.
I totally understand that, but it appears that the actual court proceeding, which would be the beginning of court, a continuance is the end of court, in my view. I mean, this is my personal view, and I'm not an attorney, but I've dealt with a lot of that. The actual proceeding started on December 28 of 2022. There was a continuance, and the actual ruling was, I guess, February 13. That's what I've got in my notes. But I just see the process starting on the 28th, which would put them in violation of it, even though I have total understanding of their lack of knowledge of this. But since there's other cases, it's been ruled to uphold the letter of the law as far as the beginning of court. I don't know, what do you feel the starting date of court versus the ending date? What do you? Does that violate if we start on the, because that's when the process starts.
I apologize. I just have to note for under the Uniform Administrative Procedures Act and our recording requirements, there is no recording of that December 28th hearing. It was not recorded as a hearing by the administrative judge. So I would play it for you if you wanted to hear that.
Okay.
That would otherwise have larger ramifications for us as an agency and virtually every proceeding the administrative judges do.
But it is a fact that they did have
some sort of proceeding, but under
date, but we don't have the recording.
It would not have been a hearing that would have been recorded. It would either have been a pre-hearing conference or other exception under the Uniform Administrative Procedures Act. The proceeding certainly, but just to get the technical vocabulary correct, as it would make dramatic difference for both the Administrative Procedures Division and our continued operations here with the state board.
But there was a decision of a continuance made on December 28th. So we do have an article from their proceedings on December 28th.
Yes, so the UAPA is just very particular when it comes to what proceedings are actually hearing on the merits and subject to certain recording and stenographer requirements versus what are pre-hearing conferences and perhaps not required to be recorded. And so I'm pointing out that there is no audio recording of that December 28th proceeding. There is a recording of the later one that the administrative judge wrote the order on fully. Just pointing that out for the record, and that there is a legal difference between those proceedings as an administrative agency is something that we deal with. But certainly you are correct. The proceedings
did occur.
The notice of hearing, as you can see in the administrative record, did notice the hearing for December 28th.
And I guess a question to our counsel is that order of continuance is a legal document from a hearing on December 28th.
Yes, it's, yeah.
So in my view, the legalities of this case started on December 28th.
So the charge to the commission, I'll just, as part of my roles of judge, is the charge of this case, and your options to are quite varied. You have a wide discretion. You can affirm that decision. And again, we're here to review the decision of the administrative judge. Or you can remand the case for further proceedings or reverse that decision. Like I said at the start, you have the points of if you find the rights of the petitioner were made in violation of some statutory, there's some unlawful procedure or abuse of that procedure, the decision was arbitrary and capricious or unsupported by evidence that is both substantial and material. Additionally, I believe it would be fair to say if you as the commission determined there was some factual finding is essential and was not made by the judge in that order and needs to be made in order to have a fair hearing, the proper relief would be to remand it back to the administrative judge with that instruction of what an essential fact they did not determine and how it may have impacted. But if you otherwise find that the order on its face is correct and decided correctly by the administrative judge, you are free to affirm the decision. So there's some wide discretion for you to do. What you are not able to do is retry the facts or define what is considered a contested case hearing outside of the definitions of the Uniform Administrative Procedures Act. Certainly all those facts you are able to take in mind, but wide discretion on what you would like to do. At this point, you're welcome to continue deliberations or ask any further questions of your legal counsel. If you want to reopen questions of the parties, we'll have to exit deliberation.
Can I hear a motion?
I'm sorry,
With-
everyone. I got knocked off.
with regret and sympathy, the same as in some of the previous cases where the judges have looked at that and in the Children's Ranch as well as other cases. I really think that, anyway, my motion is to uphold the administrative judge's decision.
Okay, we got a motion to affirm the administrative law judge's decision. Do I have a second?
Second.
So be it.
All those in favor?
Aye.
Aye.
All those opposed? Guys, carry it unanimously. The motion is motion to affirm the administrative law judge is carried. With that said, we'll do a final written order within 90 days of today's decision. That concludes our business for Who Risky today. Our final case is Mr. Austin. You are free to go as well, Mr. Sharp. Our final case, apologies, is for Mr. Gooden. Mr. Gooden, can you give us a shout? All right, perfect. I apologize for that delay. I think I misunderstood the amount of time originally requested for this appeal. I thought it was 30 minutes each. I heard it's about 30 minutes total. So we are on your appeal. I'll briefly ask, does anyone need a break before we launch in? We only have about 30 minutes left, I think. Okay. Mr. Gooden, are you ready to proceed?
Yes.
All right, I got to read through a couple of things real quick, but I'll move over that just as quick as I can. So we've got a certified technical record in here. I'm going to review the initial decision in order. That's why we are here today. All right, I have an initial decision in order entered by the administrative judge on, April 18th, 2023 by Administrative Judge Lee Thomas. The case is captioned with Felix Gooden, petitioner versus the Shelby County Assessor's Office, respondent. This is APD case number 53.01-230557J, SBOE number 137441, parcel D0147J. A00074 for tax years 2021, and then was amended to include tax years 2022 and 2023, and also has an assessor's counterclaim. Initial decision in order, the Shelby County Board of Equalization hereinafter the local board value the subject property for tax year 2021 as follows: a land value of $16,500, an improvement value of $73,500 for a total value of $90,000, and an assessment of $22,500. The taxpayer, Mr. Felix Gooden, timely filed an appeal with the State Board of Equalization, hereinafter State Board, for tax year 2021. The Shelby County Assessor's Office, hereinafter the assessor, filed a counterclaim, and notes a footnote in this matter. The assessor's counterclaim alleged that the local board valuation was lower than the fair market value for tax year 2021. At the hearing, the assessor asked the local board value be affirmed, rendering the counterclaim moot. On March 30th, 2023, the undersigned administrative judge conducted a hearing in person at the assessor's office. Mr. Gooden participated in the hearing on his own behalf. Elmer Moore III, Shelby County Assessor's Office's Office Manager of Appeal, Operations, and Appraisal Analytics, and James Polk, Senior Appraiser, participated in the hearing on behalf of the assessor. Counsel for the assessor's office, Janika White, observed the hearing but did not participate. At hearing without objection from the assessor, the taxpayers amended the appeal to include tax years 2022 and 2023. The next page, three exhibits were entered into evidence over the course of the hearing. Exhibit 1, taxpayers collective, here, that is the list of reasons for appeal, list of comparable sales, and photos of the subject property. Exhibit 2, assessor's 2021 valuation and supporting documents. Exhibit 3, taxpayers list of comparable property sales from assessor's website. And then at footnote 2, it notes that there were 2 errors on page 2 of the assessor's valuation that were addressed on the record during the hearing. Although page 2 erroneously indicated a contended land value for the property of $33,900, the actual analysis relies on the correct local board land value of $16,500. In addition, although the property is shown as not having car storage on page 2, the 2-car garage is correctly accounted for in the adjusted grid and analysis of comparable sales. Back to the issue for determination. The issue to be determined is whether the taxpayer has proven by a preponderance of the evidence that the value of the subject property should be lowered from the value adopted by the local board. Based upon the following findings of fact and conclusions of law, it is determined that the local board valuation should be affirmed. Findings of fact. 1. The subject property is a residential tract located at 4612 Cedar Branch Circle in Memphis, Tennessee. 2. The tract is 0.2296 acres and is improved with a 1,432 square foot house. Fact 3. The house was built in 2002 and has 3 bedrooms and 2 baths, a covered porch, and a garage. 4. The property has not been renovated or updated other than replacing some of the windows and wood around the windows in 2011. 5. The taxpayer contends the property is worth $60,000, which equates to approximately $41.90 per square foot. 6. Photographs submitted by the taxpayer document roof damage, water damage to the ceiling of the covered porch and garage, cracks in the door frame from a previous break-in, exterior rotten wood around some windows, a hole in the garage wall, damage to some interior walls, flooring damage, and worn carpet in the house interior. 7. A large circular area in the back of the yard where an above-ground swimming pool was previously located is at a slightly lower level than the rest of the backyard. While the retaining wall adjacent to the property is in need of repair, it is unclear from the record whether the wall is on the subject property or the neighboring tract. 9. The taxpayer presented a list of comparable sales that were of similar size and had a garage like the subject property. However, none of the comparables were adjusted. Most of the taxpayer's testimony was about exterior updates to the house across the street from his property. Taxpayers comparable 5, assessors comparable 1. Although the assessor asked that the local board value of $90,000, that is 62.85 per square foot, be affirmed, the assessor relied on 5 comparable sales to support a contended valuation of $128,000 for the property. After applying a cost to cure of $7,400, the assessor's valuation of the property was reduced to $120,600. 11. 2 of the comparables used by the assessor were of houses that were significantly different in size than the subject property. However, the comparables were properly adjusted to bring them in line with the size of the subject. 12. The comparables relied upon by the assessor's office were of similar age, location, and condition as the subject property and were properly adjusted. Although the assessor's office valuation valued the subject property as if it did not have a fireplace, this error led to a lower valuation than if the fireplace was included in the calculations. 13. The assessor's office's cost to cure included removal of the covered porch, replacement of damaged wood from around the windows and from the break-in, replacement of shingles, repairing/replacing and repainting sheetrock from damage to the ceiling and walls, and replacing the floor in the kitchen. 14. During the course of the hearing, the assessor recalculated the cost to cure to include repair of additional issues indicated by the taxpayer's testimony, which would have reduced the assessor's final valuation by around $2,000 to approximately $118,600. Applicable law. A party challenging the current assessment of a property has a burden of proof. To meet the burden of proof, the party seeking to change the assessed value must show that a preponderance of the evidence supports that change. A preponderance of the evidence means that, considering all relevant evidence, a party's contention of value is more likely than not. Pursuant to Tennessee Code annotated section 67-5-601 subsection A, quote, the value of all property shall be ascertained from the evidence of its sound, intrinsic, and immediate value for purposes of sale between a willing seller and a willing buyer without consideration of speculative values, end quote. Merely disproving assumptions underlying the current valuation or pointing out, quote, the likelihood that a more accurate value is possible, end quote, without more, neither invalidates the levy or judgment under appeal, nor constitutes a prima facie case for a change. And then she cites Coal Creek Company. Analysis and conclusions of law. Upon a thorough review of the evidence submitted in this matter, the undersigned administrative judge finds that the taxpayer has not met the burden of proof to justify a decrease in the local board's value. The taxpayer's testimony indicates that the property is in need of several, mostly cosmetic repairs. While the taxpayer did submit 5 comparable sales in support of his value contention of $60,000, no adjustments were made to the comparables. The bulk of the taxpayer's testimony was limited to the house across the street, which was remodeled in 2019 and has an unadjusted sales price of $121,000. Significantly, 4 of the 5 comparables had an unadjusted value between $88,500 and $95,400, which brackets the local board value of $90,000 for the subject property. In contrast, the evidence submitted by the assessor supports an affirmation of the local board's value. The assessor's valuation is well supported by properly adjusted comparables that are significantly similar in age, location, and condition. The assessor's contended value of $120,600 already includes a deduction for a cost to cure, which addresses most of the taxpayer's concerns. Even if that cost to cure is increased and the contended value decreased to account for the additional issues identified by the taxpayer during his testimony, the assessor's proof supports a value well in excess of the local board's value. Determination. It is therefore ordered that the local board for tax year 2021 is affirmed and adopted for tax years 2022 and 2023. That is a land value of $16,500, an improvement value of $73,500 for a total value of $90,000 and an assessment of $22,500. Is there an order entered on April 18th, 2023. Concludes with applicable remedies, which includes appeal to this body, which is why we are here today. With that said, I will otherwise hand it over to Mr. Gooden. Mr. Gooden, please introduce yourself. And I usually ask people if you could identify what relief that is what you are asking for the commission to do today, but the floor is otherwise yours to present your arguments on appeal.
My name is Felix Good. I'm just asking the board to lower my value because of the condition of my house. The houses that was used against me was remodeled on the outside and inside across the street from me at 4605 Cedar Branch. I had the judge to go online, and that's the kitchen, all those new appliances, the bathroom, all that stuff been remodeled, repainted inside and outside. My house do not compare to that house in any kind of way. The house on Sunridge, that house is less than 1,100 square feet. It don't have a garage, and that house been remodeled inside. That is too small. That is too small to compare to my house and don't have a garage. I presented houses that was more like my house that they could have used. They used houses that would get the price way up. And even there, it got superb on the house. That it's in good condition, because it's been remodeled. So to use a house like that don't have a garage and that much smaller, I see what he's doing, and that's not right. Because my house have not been remodeled and have a lot of damage. And that retainer wall is creating a erosion problem for my house. That they didn't even address that. The way they addressed that it wasn't on my property, but it is affecting my house. And in the back of my house, it's a corrosion problem. It was a bunch of trees that was planted along the fence to stop the corrosion problem. The trees is knocking the fence down. Plus, on top of that, I have a big hole in the yard where I'm in the process of moving the swimming pool that was there. You know, those issues was not addressed. And the house across the street, when I first mentioned about, you know, all of the work, I even mentioned that house even had a new air conditioner. My house don't. My house is in need of everything. I replaced these windows once after I bought the house, and now the windows is back in the same situation. Okay, they use the house on Longtree. It is superb. It is a brick house. So they constantly use houses that was in good condition and then compare my house to those houses and came up with a real high price. The house that's at 4528 Longtree. And so that is not giving me a fair price for the condition that my house is in. You know, the houses that I use range from 87 to 95, and some of these houses is 1598 square feet, 1570 square feet, 1545 square feet, which is close to the size of my house. And the price per square feet was ranging from $54 a square feet, $61 a square feet, $57 a square feet, and they don't have the damage that my house has. So it's no way that I can get $90,000 for this house based on the condition and all the problems that's going on with it. I pointed out that I could only get about $60,000 for this house because I would have to sell it to an investor. I told the judge at the hearing, I know I can't get 60, but I asked her to lower it from 90 because I know I couldn't get 90 for it. The house is, I can't even put the house up for sale, the condition it is in. I can only sell it to an investor. And that's one of the problems. The investors is in this area with signs up, we buy a house. It's hard to sell a house in this area for an individual. So I asked that the house be lowered from 90 because of the condition it's in. all the information and what I said it's on record. It's on record. So, you know, I asked for about $60 a square feet, which would brought it down. I knew I couldn't get 60. I was only stating that was all I could get. But I asked them to lower it from 90 because of the condition.
All right. At this point, I guess I'll ask any questions from our commission members.
I have one. Mr. Gooden, you're wanting the value to be what amount of total value of your property?
At least by 85, and I know I can't get that, but I know I need to do a lot of repairs. It's no way that I can get $90,000 for this house. If you look at the list of a comparable that I sent in, and you look at the range, you know, I sort of, you know, looked at that and I said, you know, the condition of my house in, I wouldn't be, you know, I couldn't even get 85. But I went back to the judge. I sent her an email because I tried to get her to reconsider, and I explained to her what I was saying about the 60. I knew I couldn't get 60, but I was saying that's really all. You know, I knew I couldn't get 90, but I knew I couldn't get 60. But I was asking her to lower it because of the condition of the house.
You're referring to your sales analysis that's on the administrative record of 0041. It's handwritten. It has 5 sales, starting with King Valley.
Right.
Yes. Okay. I'm looking at that. Yes. Thank you, sir. Are these houses comparable to yours?
Yes.
Okay.
They're the same size, a little bit larger, one a little bit smaller, but it's a brick house.
Mm-hmm.
My house is not brick, just have a little brick going across the front to make it look like a brick house. When they built this house, they built a retaining wall and put wood there. Part of the retaining wall been replaced with brick, but it wasn't done right. It's still a gap between the wood and the brick.
And that's on someone else's property?
Yes.
But the water still comes over on you?
It's watching my house was up on a hill, and they built a retainer wall to hold the dirt up to my house. And they built it out of wood.
Okay. I have no other questions. Thank you, sir.
No questions.
So you hear no more questions, I'll hand it over to the assessor's office. I'm not sure if that's Mr. Moore or Ms. White, whoever wants to present for the assessor's office. Just give us a shout. Make sure we can hear you, and then take it over.
All right. Good afternoon. This is Janika White for the Shelby County Assessor's Office. Can you all hear me okay?
Yes, thank you.
Okay. We are requesting that you all affirm the decision of the administrative law judge. As you all know, in these proceedings, in order for there to be a change, and it does not appear that Mr. Gooden is alleging any violation of constitutional or statutory provision, that there's been some type of unlawful procedure, or even that the decision of the administrative law judge is arbitrary or capricious. In fact, the administrative law judge clearly stated that the assessor's office used appropriate appraisal, they appraised the property properly, and that they also made the appropriate adjustments to address the concerns that Mr. Gooden has mentioned. Additionally, even in more so support of the decision of the administrative law judge, Mr. Gooden stated that the other properties that even he presented, which he believes to be comparable, ranged from, as stated in the decision from the administrative law judge, between $88,500 and $95,400. In this instance, the assessor's office had a contended value of $120,600, which included the adjustments of the comparable sales, and are only requesting that you all uphold the local board value of $90,000 of the subject property. Not considering any new evidence, which I don't believe any new evidence has been presented, and even considering the comparables that were presented by Mr. Gooden, as stated in the admin law judge's decision, none of those comparables were adjusted at all, which was properly done by the assessor's office. So we are asking, and of course, in this instance, Mr. Gooden did have the burden of proof, and it's our contention that the board value of $90,000 should be upheld.
Any questions of Ms. White from our commission members?
Is that for me?
I'm asking our commission members. Just a second, Mr. Gooden. All right. Hearing and seeing no questions of the assessor's office, Mr. Gooden, any closing remarks?
Oh, that's just like the house on Rosswood that they used with 2,000 and some square feet. That's too big. You know, and I put all of that in my appeal. You know, the house on Rosswood was 2,000 and some square feet. To use those big houses and small houses and remodel houses on the inside and out to compare my house to. You know, it's too much damage to my house.
Okay. Well, thank you. We'll otherwise went to deliberations, I guess, at this point in time. I guess correct me if I'm wrong, Commission, but from here on out, this is our final case of the day. Once we enter deliberation, there'll be no more communication. If we need to answer any questions, we'll have to exit deliberations. We can do that. I'll hand it over to a presiding member, Mr. Osborne, for that.
Without any discussion, do I have a motion?
Make a motion, we uphold the assessor's value.
Been made to uphold the assessor's value.
Second the motion.
So just the decision of the administrative judge.
Administrative judge.
Okay.
I make amendment to the administrative judge.
And we have a second to the administrative judge decision.
Second.
Yep.
Second.
All right. All in favor, say aye.
Aye.
All opposed? The ayes have it. So the decision of the administrative law judge is affirmed. That concludes the business for this appeal today, and all the business for the commission for today, Tuesday, December 12th. With that, thank you, everyone. I'll otherwise end the call, and this will conclude our business for today. We'll send that final written order within 90 days of today as well. And we are adjourned. Thank you.
Thank you.